All right. Good morning. This is Renee Line, Chair of the Colorado Real Estate Commission. It is 9 o'clock, August 5th, 2025. This is a public meeting of the Real Estate Commission, and we will now call this meeting to order. Director Waters, would you like to do roll call?
Renee Line.
Here.
Adam Rubal.
Here.
Erica Saunders.
Here.
Erica Doyle.
Here.
Bernadette Bougarin is excused. You have a quorum. And commissioners, before you get into your order of business, on behalf of the Colorado Office of Policy Research and Regulatory Reform, otherwise known as COPR, they've asked that I just let you know that they are currently wrapping up the sunset review of the Colorado Real Estate Commission. COPR is still accepting input and can hold meetings throughout the month of August. The report is scheduled for release on October 15th of 2025. And we'll go to the General Assembly to create legislation on the commission next year. If you would like to participate, please email Sahib Singh at sahib@state.co.us. His phone number is 303-894-7833. And you may also leave written comments online at the following URL. It's coprr.colorado.gov/participate. And that's it.
Okay. David, did you want to talk about the CE?
Thank you, Madam Chair. Licensees that are attending today's meeting are eligible for continuing education, provided that the duration of this meeting is long enough. So I have placed a poll up on the screen for anyone that is seeking continuing education credit for today's meeting. Please complete that poll, and then just a reminder that you must attend for the required duration, which is at least 2 hours, in order to receive any credit. If you have any issues with this poll, rather than addressing it with the in the public session of this meeting, please deliver an email to myself at David, that's DAVID, Donnelly, DONNELLY @state.co.us in order to obtain that credit. And with that, Madam Chair, thank you very much. As the licensees continue to answer the poll question, I'll pass control of the meeting back to you, and then I will bring the poll down in a few moments. Thank you.
Thanks, David. Okay, so we need to approve the minutes from the last meeting. So can I have a motion to approve the board meeting minutes from June 3rd, 2025?
Motion to approve the minutes.
Do I have a second?
Second.
Okay, Erica. All right, so there's been a motion and a second. Any discussion? No discussion, so we'll take a vote. All those in favor?
Aye.
Aye. Okay, so that was 4-4. Any opposed? No. Okay, so we have 4. Motion passes. All right, so next on the agenda is public presentation. David or Marcia, are you doing?
I'm not sure where David went, but if you wish to make comments to the Real Estate Commission about issues not on today's agenda, please raise your hand and we will call on you.
Forgive me, I was having some issues with my audio there. Yes, any members of the public that would like to address the board, please raise your hand. Commissioners, we have a few members already. Mr. Peterson, I have just selected you to, and you have unmuted. So I will move a timer over here, and please proceed, Mr. Peterson.
Just as a point of order, this is for comments or presentation of matters that are not on the agenda. My comments are related to the approval of the forms. That said, I don't see any other place on the agenda where there will be you'll be receiving any public comment related to forms. So if this isn't the appropriate place and there's intention to accept public comment at some other point in the agenda, please let me know.
So There will be a portion during the non-rulemaking hearing where people can make comments about the forms.
Then I will lower my hand. Thank you.
All right. Let's see. And I think that inquiry from Mr. Peterson may have brought down one other hand, but Robert, I've allowed you to unmute.
Yes, I'm following up on an email I sent in with a proposed change for the seller property disclosure form. And this relates to the transparency for metropolitan districts. There's a Senate Bill 23-110 that requires the seller to provide the metropolitan district website on the seller property disclosure form as approved by the Colorado Real Estate Commission. It doesn't seem like that's an option. I got a response back that, well, we already have it in the contract. However, I don't think that that complies with Senate Bill 23-110, which says on or after January 1st, 2024, the seller of residential property located within a metropolitan district is required to provide the purchaser of the property with the official website of the metropolitan district on the Colorado Real Estate Commission approved seller property disclosure form. That's it.
Okay. Thank you for that. I think that's a great idea.
Thank you, Robert. And then Casey, I have asked you to unmute.
Hi, I also have a comment about the form, so I will wait until later.
Very good. Thank you.
Thanks.
All right.
Quick point of order. I'm realizing that my battery on my computer is low, so I do need to step away to grab my charger real fast. I apologize for that.
Okay, go grab that.
Seeing no other hands at this time, commissioners, I believe we can move on to the next agenda item as Erica is able to get her plug.
Okay.
Okay, thank you. I'm back.
All right.
And charging.
Okay, so the next issue on the agenda is hearing matter A, which is the matter of Casey Dunn, case number RC 2025-0006. The matter is before the commission today for review of the initial decision and issuance of a final agency order. Present to assist the commission in reaching a final agency order are Melissa Phipps, Senior Advisor, and Marcia Waters, Division Director. An initial decision upon default was issued in this matter on April 3rd, 2025. Neither party has filed exceptions on the initial decision, and the matter is now before you on the commission's own motion to review the initial decision. The commission needs to deliberate on whether to adopt, modify, or otherwise act on the initial decision and proceed to a final agency order and final discipline, if any. And I guess that was, sorry, it was actually April 30th. Ms. Phipps, can you please provide a brief overview of the issues to be considered by the commission?
Yes, thank you, Commissioner Line. And good morning, commissioners. Before we get started, I just wanted to take a quick second to highlight the scope of our discussion today regarding both hearing matters A and B. Director Waters and myself are available to answer any general questions that you may have regarding the matters, but just a reminder that we cannot offer legal advice, and your general counsel and any other attorneys from the AG's office are not able to participate in any discussion or answer any questions regarding these two matters because the way our system is set up, they are walled off from this portion of the process. since they participated in the prosecution of the case. So for purposes of today's meeting, you don't have conflicts counsel. You basically have myself and Director Waters to kind of help you through your discussions and deliberations to any extent that we can. So jumping into hearing matter A, as Commissioner Line said, that is the case involving Casey Dunn, RC 2025-0006. And the issues in this case were addressed in the memo that you received prior to this meeting, but I'll just take a second to quickly highlight them here. The first issue that was raised and discussed in the memo was whether respondent can be compelled to complete coursework after revocation. And it's division staff's recommendation that given the recommended revocation of respondent's real estate broker's license, we would recommend that a final agency order that you choose to issue in this case does not also impose the requirement to complete coursework. And then the second issue is the initial decision's recommendation of the imposition of a high level of supervision upon reinstatement of respondent's license. So the initial decision, the exact wording is recommends imposition of a high level of supervision for 2 years upon reinstatement of respondent's license. And our concern with that is really the way that that is worded, as it could be interpreted to imply that respondent's ability to practice as a real estate broker under her current license will in fact be reinstated or restored at some future date. It's really kind of that use of that word reinstatement, because that I think kind of implies that that is going to happen. That's an automatic reinstatement. And if you proceed to go forward with the revocation, then she's not going to be automatically reinstated at any point in the future. She will have to reapply and have a license application approved. And that language about reinstatement, I think, may have been relevant because as I outlined in the memo, this case kind of went through a couple stages where you made an initial disciplinary recommendation, but then it went to the AG's office and came back with a kind of an updated recommendation where revocation was ordered. So that reinstatement was really relevant to the initial disciplinary recommendation, but not so much to the one that you guys ended up with, which is revocation. So staff would recommend that the language regarding a high level of supervision would be removed if you guys do in fact choose to order revocation. So those are the issues that the staff sees. If the commission has any questions, like I've said, Director Waters or I can answer them. Otherwise, we'll leave it for your discussion as to how to proceed. Thank you.
Okay, thank you, Ms. Phipps. Any commissioner like to open discussion on this?
I'm happy to. I do agree with what staff is recommending. I also felt that it was unnecessary and even confusing to have the requirement of additional, higher level supervision, as well as coursework down the line, because it does give the impression that it's attaching to that original license. So I think that we should just proceed without those items. And after discussion, if everyone agrees with that, I'm happy to make a motion.
Okay, anyone else have any other comments?
I agree. Believe that we needed to impose any requirement for the coursework since we're revoking. Same thing with the high level of supervision. You would need to reapply, so you're subject to that. So I would be okay with removing the requirement of the high level of supervision. I can make a motion, or if you want to make a motion, Erica, either way. And
yeah, Autumn, did you have any?
Yeah, you guys hit the nail on the head, so agreed.
Okay. Sure. I can make a motion. I have it right here. Okay, give me just 1 second, sorry. Okay, motion to modify the sanctions recommended in the initial decision to order the following discipline. Respondent shall be publicly censored, including the right of the commission to publish this final agency order. Respondent shall pay a civil penalty of $12,500 plus the 15% statutory surcharge pursuant to paragraph 24-34-108 CRS for a total amount of $14,375. Such amount shall be due and payable within 30 days from the date of this final agency order. And respondent's real estate broker license is hereby revoked, and otherwise adopt the remainder of the initial decision in its entirety.
Okay, do we have a second?
Second. Do we need to also add on there that we are delegating authority?
That's a separate motion.
Separate, yep, but yes.
Okay, great.
Okay, all right. All those in favor of the motion Erica just made?
Aye.
Aye. Any opposed? Okay, motion passes. Okay, Erica, did you want to do the next motion?
Me or Doyle?
Erica Doyle could do it since she brought that up, if you want to do that.
I would just move to delegate authority to the division to make the revisions as well as any necessary non-substantive revisions, then execute and serve the FAO.
Okay, do we have a second?
Second.
Okay. Is there any discussion? No? All right, all those in favor?
Aye.
Aye.
All right, motion passes, or I guess I should say any opposed. I think everyone voted yes. Okay, all right. So a final agency order reflecting the commission's decision will be issued in due course, and a copy will be mailed to the parties by commission staff. Next item on the agenda is hearing matter B, which is the matter of Colette Ledlow, case number RC 2025-0009. The matter is before the commission today for review of the initial decision and issuance of a final agency order. Present to assist the commission in reaching a final agency order are Melissa Phipps, Senior Advisor, and Marcia Waters, Division Director. An initial decision upon default was issued in this matter on June 4th, 2025. Neither party has filed exceptions to the initial decision, and the matter is now before you on the commission's own motion to review the initial decision. The commission needs to deliberate on whether to adopt, modify, or otherwise act on the initial decision and proceed to a final agency order and final discipline, if any. Ms. Phipps, can you please provide a brief overview of the issues to be considered by the commission?
Yes, thank you. So just for a point of reference, this matter is very similar to the Prather matter that you guys considered at your last meeting. I don't know if you remember that at all, but it's very similar issues presented, and I think it may in fact be the same ALJ. So I'll just take a brief second to review the issues again, but they were thoroughly discussed in the memo that you received before the meeting. So the first issue is the suggestion to incorporate the notice of charges into the final agency order. And as you've seen by reviewing the initial decision, it was very basic and really lacked any details regarding the case. And the ALJ didn't make any specific findings of fact or conclusions of law, instead just stating that she finds and concludes that the allegations in the notice of charges are established. So again, the division staff recommends strengthening that FAO by incorporating the notice of charges into the FAO. And that is accomplished simply by including language in the final agency order stating that the notice of charges is incorporated by reference. And then by doing that, all the facts and allegations contained in the notice of charges become part of the FAO. And then the actual notice of charges document also becomes an attachment to the FAO. And the second issue is the ALJ's refusal to impose that statutory surcharge on the fine. So the initial decision did recommend that the respondent pay the fine as requested by the commission. However, the ALJ did decline to impose that statutory surcharge. And the ALJ's reasoning was that the relevant statutory surcharge, the statute grants authority to the executive director of DORA to collect the surcharge and not the division. but however, the division regularly collects that surcharge, and we do so pursuant to a delegation of authority from the executive director of DORA to collect that surcharge on her behalf. And we regularly do that. We have for a long time. So staff respectfully disagrees with ALJ's determination regarding our ability to impose the surcharge, and we recommend that in an FAO that you issue that the surcharge is imposed on any fine that you order. So those are the issues, and that's a little bit of the background. Commissioner Lind, I'll turn it back over to you. And again, if you guys have any questions, Director Waters and I are here to answer them for you. Thank you.
Okay, thank you, Ms. Phipps. Would any commissioner like to start discussion?
I can start. I reviewed everything on there as well, and I think that we can incorporate that notice of charges by reference. And it does look like the ALJ erred in refusing to impose that surcharge. That is something that we do on a regular basis. So I am clear on that one. I would just ask the other commissioners their thoughts on that as well.
I agree. I definitely don't take issue with adding that surcharge. And I know that we, to Melissa's point, we did have this come up recently. And to my knowledge, that was all successful when we kind of added similar language. So I would move to do the modification.
Autumn?
Agreed. Yeah.
Okay, all right.
I can go ahead and motion if you like,
Okay.
since I have it right here.
All
A
right.
long motion.
It is. A motion to modify the initial decision in the following manner, excuse me, to incorporate the notice of charges into the final agency order by reference and impose a 15% statutory surcharge on the $2,500 fine for a total amount to be paid of $2,875, and otherwise adopt the remainder of the initial decision in its entirety.
Okay, thank you, Erica. Do we have a second?
Second.
Do we have any discussion? All right, let's take a vote. All those in favor?
Aye.
Aye. Any opposed? All right, motion passes. Now we need the second motion.
I would motion to delegate authority to the division to make the revisions, as well as any necessary non-substantive revisions, then execute and serve the FAO.
Okay, do we have a second?
I'll second.
Okay,
Go ahead,
Autumn.
Autumn. Yeah.
All right, any discussion? Okay, all those in favor?
Aye.
Aye.
Aye, any opposed? Okay, motion passes. All right. Final agency order reflecting the commission's decision will be issued in due course, and a copy will be mailed to the parties by commission staff. So this concludes the hearing matters for today. We will now move in to executive session. Out. Okay. All right, this is Commission Chair Renee Line. This is a Colorado Real Estate Commission meeting being conducted on August 5th, 2025. The time is now 9:24 a.m. I move the commission enter into executive session pursuant to Colorado Revised Statute, Section 24-6-402 3A2 for the following purpose: to confer with counsel to receive legal advice on specific legal questions regarding to the following meeting agenda items. Policy Matter A, Commission Rule 6.3G. Is there a second?
Second.
Okay, all those in favor?
Aye.
Aye. And
Aye. Sorry, I'm having issues with my mute button.
okay, all right. There are 4 votes in favor of executive session. We will now enter into executive session. So make sure you turn off your video and microphone.
United States, this way, how can I help you?
So commissioners, it looks like you're all back. If you would like to now move into policy matters.
Okay, so policy matters A deals with Commission Rule 6.3G, which we discussed. Like to make a motion to direct division staff to move forward with rulemaking in regards to informed consent and to draft a new position statement regarding supervision and confidential information and to amend any current position statements as needed.
Second.
Okay, any discussion? Okay, then we'll take a vote. All those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, motion carries. And now we'll turn it over to Director Waters for policy matter B.
So commissioners, is there anything that you would like placed on your agenda for the October meeting?
None here.
Not at this time.
None.
Okay,
All
that
right.
leads us into the non-rulemaking hearing.
Okay. All right. So the Colorado Real Estate Commission has the authority to promulgate real estate forms for current use by real estate brokers pursuant to section 12-10-403 CRS. These forms are referred to as commission-approved forms. The purpose of this hearing is to hear oral testimony and accept written submissions relating to the following commission-approved forms. Do you want me to read all these?
I could
Marsha?
read them for you if you'd like.
Well, I can read, all right. Manufactured home contract extension or termination of contract, new. Agreement to revive contract, manufactured home contract to buy and sell, new. Manufactured home contract to buy and sell. Exclusive right to lease listing contract. Exclusive tenant listing contract. Exclusive right to buy listing contract. Exclusive right to sell listing contract. Seller association authorization, seller's property disclosure, closing instructions, post-closing occupancy agreement, inspection objection notice, extension or termination of contract, agreement to revive contract, contract to buy and sell real estate. Okay, so in addition to my fellow commissioners, here with me today are Director Waters, Deputy Director Lyle, Senior Advisor Phipps, Board Liaison Doreen Archuleta from the Division of Real Estate. And I think Gina's off, so that will be Irina Groni from the Attorney General's office. The public record will consist of all testimony and any written information submitted within the allowable time frame. In addition to the public comments today, the commission will review any written materials to make the final decision on the proposed new and modified forms. The public record will close at the end of this hearing. So now Senior Advisor Phipps will explain the proposed modified forms.
So commissioners, before Melissa starts in on her summary of the changes, I did want to let you know that we are working with the Attorney General's office with somebody in their intellectual property section about some language to put at the top of your forms to make it very clear that these are the Real Estate Commission's forms, not just approved by you all, but they're your forms, and that modifications of these forms are only permissible based on commission rules. So as you look at these, they don't have that draft language yet, but that is something that we will be adding to your forms as a result of working with the AG's office. And with that, I'll turn it over to Melissa.
All right, thank you. And then as an initial matter, before I start going through each of the forms individually, I also wanted to talk about some additional language in the headers and footers that's going to be on all of the forms. And this language is on the versions that you have before you today, but I just wanted to cover it once so I didn't have to cover it each time we went through each form individually. And that is that previously the header contained an abbreviated code that represented the form name and the month and year of adoption of that particular version of the form. And then the footer contained the same information along with a full text of the form name. And division staff has received a fair amount of feedback that that abbreviated code of letters and numbers was confusing to some brokers and some forms providers, as well as we also got some feedback that people weren't sure what that date in fact represented. So this proposed change to the headers and footers that is made with the intention to make the pertinent details more explicit. And what you'll see on all of the proposed forms that are before you today, that previous code is still there, but the full name of the contract is now in the header as well. And then the header also clearly states both the adoption date and the mandatory use date of that particular form. And then the footer change, it only removes that adoption date, which would have, like previously, just said 6/23 without any context of what that 6/23, for example, meant. So the footer still contains the code, and the full name of the form just eliminates that date representing the adoption date, because that's now explicitly put in the header. So does the commission have any questions or concerns about that particular change before we move forward?
Nope.
Not seeing any. Okay. So like I said, because that change applies to all of the forms, I won't spend time explaining it when I go through each of the forms individually. Just please remember when you vote to adopt each form that this change is one of the factors that you should be considering when you make that vote to adopt. Okay. So now I'll go through the forms that are on the agenda in the order that they are listed on the agenda. And then after I have explained the proposed revisions to a form, the commission can discuss the changes and take a vote on the adoption of that particular form. And then I'll move on to the next form. So the commission will be considering and voting on each form individually as we move through. All right, I think that's all of the background that I had for you guys. The only other thing that I wanted to mention is that David Donnelly has been kind enough to volunteer to share his screen to display the forms in order to make it easier for everyone to follow along as I'm going through. So, let's see. Yep, David's already on the ball and has got the first one up there. So that first one is the manufactured home contract lot lease only extension or termination of contract. And this is a new form that was created this year. As you're aware, there's already a commission approved extension or termination of contract that is presently used for all versions of the CBS. So this contract was created so that there's a form that is specific to the manufactured home CBS. Currently, the only option for brokers is to use the general extension or termination of contract, but that form doesn't have dates and deadlines and corresponding provision numbers that are specific to the manufactured CBS. So that was the reasoning for the creation of this new form. So I'll open it up to the commission for discussion.
Okay, thank you. Anyone have any comments or questions?
I did not have any comments or questions on this document.
Same.
Okay,
No.
would someone like to make a motion to approve the form?
I make a motion to adopt the new agreement to revive contract manufactured home contract to buy and sell lot lease
No,
only.
no, we're not on the revive one, though. We're on the
Oh,
contract
sorry.
extension or
I'm on the wrong
termination.
one. Sorry.
Okay.
Hold on. I can't see the top on the screen. So let me
It's
pull it up.
the first one on our agenda.
Yeah, I'm pulling it up. So new motion. Motion to approve or to adopt the agreement to revive contract manufactured home contract to buy and sell lot lease only.
Okay, we have a second.
Second.
Commissioners, just
Alright.
to clarify, it's the manufactured home contract extension or termination of contract form.
Okay. I'm gonna start up again. One more time. Third time. Motion to adopt the manufactured home contract extension or termination of contracts, new form.
Okay, Erica, you want a second again?
Second.
Okay, all right. Any discussion? All right, all those in favor?
Aye.
Aye.
Aye. Any opposed?
So commissioners, before you vote to adopt, do you want to see if there's any public comment that you can take into consideration?
Yes, please.
Yes.
Thank you.
Thank you, Commissioners and Director. If anyone does have any comments on this form in particular, again, we're presently speaking of the manufactured home contract for a lot lease only extension or termination of contract. Please select the raise hand icon in your Zoom platform, and we can identify you. However, Commissioners, on this form, I'm not seeing any hands from the general population. Thank you. I'll keep an eye on that for each of the next few forms as well.
Okay, so this form is adopted. Now we're on to the next one, Melissa.
Okay, and just for a point of clarification, I think if everyone's in agreement, a good way to move forward, maybe I'll go through the changes. You guys can have discussion, then a motion and a second. And then after that second has been made, then David will open it up for public comment on comments specifically to that form. Is everybody okay with that?
Yes.
Yep. Okay. All right. So the second form is the agreement to revive contract manufactured home contract to buy and sell. That is also a new form. And again, there is already a commission approved agreement to revive contract. And this one is just, this new form will be specific to the manufactured home contract to buy and sell. So similar to the previous contract, it just will eliminate brokers having to use a general catch-all form that doesn't apply specifically to the manufactured situation. This proposed new form is where it's really substantively similar to the existing form, as it's proposed to be revised with a new dates and deadlines table. However, this form has dates and deadlines and the corresponding provision numbers that are specific to the manufactured contract to buy and sell.
Okay, thank you.
That's
Any discussion? Okay, would someone like to make a motion?
Motion to approve the agreement to revive contract manufactured home contract to buy and sell lot lease only.
Do we have a second?
Second.
Once again, members of the public, if anyone has any public comment that they would like to share with the commissioners on the agreement to revive contract manufactured home contract to buy and sell lot lease only, please raise your hand in the Zoom platform. Seeing none, commissioners?
Okay, motion passes. Yeah. Melissa?
All right, moving
You have to
on
do-
to,
You need a,
Sorry, you
all
need to
in
do a
favor?
quick vote.
Yeah. We need to do a vote, Renee.
Oh, I thought we did. Sorry, skip that one, huh? Okay, all those in favor?
Aye.
Any opposed? No, motion passes.
all right, so Form 3, the manufactured home contract to buy and sell. As an initial matter, I'll just point out that there was a mistake in the footer of the filed version of the form. Nothing really substantive. It's just that the one following the MHC was accidentally deleted. And I think I already corrected it on this version that's on the screen now, so you won't see it. But that one was actually accidentally deleted, but it actually is part of that form name abbreviation. So that'll be corrected, and it'll appear as is in the footer on the screen now. So, and you can go back up to the top of the form, David. Sorry about that. The proposed changes in this contract essentially fall into two categories. The first is conforming changes with the contract to buy and sell forms that as they were revised last year. And then there's also non-substantive changes that were basically made for ease of reading and clarity. The first of those changes is in 2.4.1. Year was changed to year of manufacture for clarity. In 2.5.1, there's a non-substantive change to eliminate the unnecessary or choice of none. And 2.52, the title was inclusions not attached. However, the items listed in the provisions are a mix of items that are both attached and not attached. And taking this into account, the title is changed to inclusions additional, and the language whether attached to the home or not was added. And 2.53, the proposal is to change the position of the word inclusions just so it's consistent with the way the previous provisions are written. The remaining changes in 2.53, as well as the changes to 2.54, 2.56, 2.57, 2.58, and 2.59 are conforming changes. And the conforming change to 2.56 is substantively the same, but the language was just reworded for clarity. And then in 2.59, you'll see on the version there on the screen that's highlighted, and that's highlighted because that is a change that was not included in the versions that you guys have before you today. And that's because that was a mistake that was caught after the forms were filed with the Secretary of State. The AG's office made the suggestion to eliminate the phrase or ownership because since this is a lot lease only contract, the buyer is not going to be obtaining any ownership. That was just a carryover conforming change from the residential CBS. So that was included in by mistake, and the proposed change is to take out the or ownership. And then moving on to 2.72, just eliminating the unnecessary phrase copy of, and 2.73 and 2.74. Those are both really non-substantive revisions for the purpose of clarity. 3.1 is those are a conforming change to add in the provisions related to buyer credit that were in the other CBSs, but not in the manufactured CBS. And 3.2, elimination of the unnecessary word blank. 3.3, that's just a formatting change, fixing an error there. And 4.3, all of the changes listed in 4.3 down are all non-substantive conforming changes to wording. And if we go down to 4.41, good funds, that is also a change that was not included in the version that was presented to you prior to the meeting. The division received input from stakeholder regarding SB 25016, which was passed this year, and it amends 3835-125 CRS. So based on that legislation, a change was proposed to have 4.41 now read as followed, as presented up there on your screen. You can see that savings and loan, electronic, so certain words were deleted, and real-time or instant payment was inserted. 4.42 and 4.43, conforming changes to the formatting of paragraphs, how they are in the other versions of the CBS. 4.6 is also a conforming change. 5.3 is that change I referenced earlier in relation to the dates and deadlines table, where the credit information provision that is in the other versions of the CBS was added into this contract. And going down to 7.2.2, non-substantive change for the sake of clarity. 8.1, and this provision, part of the changes are conforming, and that is the addition of the phrase applicable Colorado Real Estate Commissions and deletion of the last sentence. That's a conforming change, but there is additionally a substantive change that is proposed, and that is that the time frame related to the completion of the SPD is changed from the date of the contract to the date of the seller's property disclosure deadline. And that proposal was precipitated by a suggestion from the Forms Committee that it isn't always feasible for sellers to have the SPD completed by the date of contract. And since that date, the seller's property disclosure deadline is already in the contract, it makes sense to allow the seller time to complete that contract until that deadline. So moving on to 8.2, non-substantive revision for clarity and accuracy. 8.3 and 8.33 are non-substantive grammatical changes. 8.4, non-substantive change for clarity. Same with 8.5. And 8.61, all of the changes are conforming. And then 8.6.2.4, that's also a conforming addition. 8.7 is a non-substantive grammatical change. 8.12, 8.92 as well are non-substantive changes for clarity. 9.1 and 9.2 are conforming changes. 10 is just a formatting change. And then 11 are mainly wording changes for clarity, but also added in the phrase unless otherwise agreed to in this contract to take into account all of the previous provisions that deal with liens and encumbrances. 12 is a conforming change. 14, all of those in section 12, sorry. 14, same with 14, all of them are conforming changes. And 15.3, it's a change for clarity. The proposed addition in 16 is a conforming change. And 17.1.1, that's a non-substantive change for accuracy. Parties is not a defined term, so it shouldn't be capitalized. And 19, it's a non-substantive change for clarity. Same with 20, it just provides an example of what written mutual instructions could include. 21.2 is a conforming change. 23.1 is we added that additional paragraph reference for accuracy to reference one of the other additional parts of that notice provision. 25 is a conforming change. Paragraph 26 is a conforming change. And then with paragraph 27, the additional provisions, the change that you see here is basically just to take that statement out of parentheses because it is an important statement. And the AG's office also suggested bolding that statement. The following additional provisions have not been approved by the Colorado Real Estate Commission. And if the commission's okay with bolding that, that's something that's a change that I'll make in all of the forms moving forward. And then 28 is a conforming change. And then the changes down below to the compensation disclosure, those are all conforming changes to the other CVSs as well. So that's all for me. I'll open it back up to the commission for discussion.
Okay, anyone have any comments? I know the bolding and the additional provisions, I would say that's good for all the contracts. Anyone else?
Agreed. I think that's a good thing. I know maybe I'm jumping the gun a little bit, but the only note I really had on this, and probably all of them, is when we get to the seller's property disclosure, it was very intentional to lowercase closing. But then in all which I didn't know why, but all the other contracts have it capitalized. Not a big deal. This is definitely just a grammatical thing, but I just wanted to point that out because it was very intentional to change closing to lowercase throughout the seller's property disclosure. So do we
And
know that they did that, and then why it's not on the other contracts?
And that's a good point. I think whether it's capitalized depends on whether it's a defined term within each individual contract. So that's something I can go back through and make sure on every contract that it's reflected accurately based on the specific conditions of that particular contract.
Perfect.
Mm.
That's the only note I had other than that.
Okay, anyone else? All right, someone want to make a motion?
All right, motion to approve the manufactured home contract to buy and sell.
We have a second.
Second.
Okay. And David, do you want to see if anyone else has any other discussion?
Once again, if any members of the public have any comments, please select the raise hand icon. Again, we are speaking now about the manufactured home contract to buy and sell, lot lease only. Giving it a few seconds here, commissioners. I am not seeing any raised hands.
Okay, and I don't know that we need to add into the motion, but are we okay with just telling Melissa that we're okay bolding the additional provisions?
Yes.
Melissa, okay.
Yep.
All right. Okay, let's take a vote. All in favor?
Aye.
Any opposed? Okay, motion to adopt the form passes.
All right, moving on to form number 4. That is the exclusive right to lease listing contract. Sorry, David's good. All right, the first proposed change is in 3.5.2. And the reasoning behind this proposal is that since the listing contract allows a box to be checked to authorize the broker to also negotiate a sale of the premises, the added language clarifies that all of the duties owed by a broker under the listing contract relating to a leasing of the premises also apply to a sale of the premises if that box in 3.52 is checked. 3.6, again, because of the checkbox option, and 3.52, the added language clarifies that the listing period applies to the completion of the lease or sale of the property. Clarifying language has also been added to make it clear that the broker must continue to assist in the completion of any lease or sale for which compensation is due and payable even after expiration of the listing contract. 4.3.1.1 and 4.3.1.2, those fixed typographical errors. 5.3, the proposed revision is to delete the entirety of this provision, and that proposal was made upon advice from the Attorney General's office. 5.8, the existing provision was worded in such a way that it could be interpreted that the broker was the party that got to make the decision whether to disclose the existence of other offers. So the proposed language was intended to clarify that is the landlord's decision whether or not to consent to such disclosure. And additional language was also added to be consistent with other provisions in the commission-approved forms, which indicate what applies if no box is checked. In this case, consent is not given. 7.1.2 and 7.2.3 are non-substantive typographical changes. 7.3 is a non-substantive typographical change, and also for clarity, payable was changed to due and payable. 7.4, that's a non-substantive change to have consistent wording. Also, language is proposed to be added similar to the last provision to be consistent with other provisions which indicate what applies if no box is checked. In this case, the broker will not be paid a fee. 8 is a non-substantive typographical change. 9.3.2, proposed change, non-substantive clarifying language. 10.3, also non-substantive grammatical change there. 10.4, same thing, non-substantive, just kind of grammar change. 16.2.5 adds in the radon disclosure required by law. And then, sorry, just give a chance to get down to that. Okay, and then 17, the proposed language is to add in a disclosure regarding whether or not the premises is located within a common interest community. And it contains an acknowledgement that if so, the landlord may have additional disclosure requirements and must obligate the tenant to those requirements by lease. 18.1, the proposal is to add in a new requirement that a landlord's notice of cancellation must be made in writing, identify the basis for cancellation, and be delivered to broker in accordance with the notice provisions in the contract. 8.2 makes the same changes in 8.1, but in this case, it pertains to the notice of cancellation made by the brokerage firm. 19 adds in language which clarifies that neither broker nor brokerage firm is obligated to advance funds for the landlord unless otherwise agreed to in writing. 20 adds the statement that a broker cannot require a landlord to use a certain settlement provider, and advises that landlord can shop for settlement services and settlement service providers, and that it is the landlord that is ultimately responsible for selecting, qualifying, and paying any settlement service providers. 21 adds in a more strengthened and more detailed wire fraud warning. Let's see. 25, just some proposed rewording, non-substantive changes just for clarity and ease of reading. 27, again, that AG suggestion to bold the language. Let's see, sorry, I gotta scroll here. 28, again, just a non-substantive clarifying language suggestion. 30.1, same additional paragraph reference for accuracy as we saw in the last form. And then in 30.3, we deleted notice because it is redundant of paragraph 30.2. So that's all I have. I'll turn it back over to the commission.
Okay, anyone have any questions or discussion?
I had a question on paragraph 17. If we can go to that.
I'm sorry, was that, Commissioner, was that 17?
17, yes. So historically, we've been referring to these as owners associations and not homeowners associations. And so when we have that as the title there, and I know this will come up in the exclusive right to sell, and then the purchase contract, we're changing those over to homeowners versus just owners. So are we making this a broad change all the way across, or should we just continue to keep this as owners association because we're using now both of those terms throughout these contracts?
And I would say I don't think that that was an intentional move to make that change. So it just may be an oversight, and I'll just leave it up to the commission of if you want everything to be consistent to make sure that any reference to homeowners is changed back to owners, or however you want to proceed.
Well, to Commissioner Doyle's point, since this is a lease listing contract, isn't it, I don't really do leasing, but is it probable that a commercial agent doing like maybe, let's say, a building or something that would make sense to use this would be using this form? Because if so, it wouldn't be homeowner, it would be owner association. So good, I didn't pay attention to that, I guess, but that's a really good point to be brought up.
Well, and I'm just thinking, you know, more for consistency, and then regardless of what they call it, because, you know, we get into common interest community, which we refer to as well. So if we're going to have a title and then have references in contracts that, you know, people are doing a variety of these, we're always calling it owners association. So, I mean, I would say, let's just change that to owners association. And then as we move forward, when we see those, we just keep it consistently across. Thoughts, Renee?
I think it should be consistent, so whichever way we want to do it, but it should be consistent. So if you guys want owners, we could have, you know, Melissa can change everything to owners association.
I like that again, because if you do have individuals doing like smaller commercial deals, they may use this form and it would not be a homeowners association. It wouldn't be referenced as a homeowners association.
Okay, and I've made note of that guidance. So when you guys make your motion, you can just say, you know, a motion for me to revise the form as advised during discussion related to paragraph 17. Something
Okay.
along that. That was very inarticulate, but hopefully you understood the point I was trying to make.
Any other discussion on the form?
I actually had one too. Hold on. Just a quick question, page 25, or sorry, section 25 under mediation. I personally found line 362 to be maybe unclear completely. And I want to make sure I'm even interpreting this right. But the way I understand the mediation, and I think what is trying to be addressed here is if for some reason an agent requests mediation and for whatever reason it doesn't happen, because that does happen where you don't get a response regarding mediation, or maybe there's just no agreement, that the obligation to mediate would now terminate after 30 days. And I don't know that it felt really clear for that, and it could just be me, but I didn't find it very clear that if there is a mediation that it can that if rather it's a scenario where the individuals didn't agree to initiate it, because that's the big piece, or if it's not resolved. Does that make sense?
It does make sense that they, yeah, and you're right, there is
I've been in that scenario where the other party just won't respond to the request. So I would personally like it to be a little more clear that it includes non-response to the mediation. But, you know, and maybe that is what this paragraph, I just want to also clarify that that is the intended interpretation of what this is saying.
I definitely see your point, and I don't know if this language predates me, so I don't know if I can speak to the, you know, the intent of that line. It could also be the obligation to mediate could
Yeah.
terminate. Is that, yeah.
I think even adding that word is helpful, particularly in those instances where you do have another party that's just not agreeing to do that.
So would that kind of you think meet your concern if it says the obligation to mediate unless otherwise agreed will
Yeah.
terminate? Okay.
Will terminate in the event the entire dispute is done. Yeah. Yep.
Okay.
Okay.
All right, I've got note of that.
Any other comments or discussion? Okay, someone want to make a motion including the two items we talked about?
Motion, oh, hold on. Let me get this in front of me. Okay, motion to approve the exclusive right to lease listing contract with the following amendments. Correction on, I'm sorry, Erica, where was that?
Section 17.
Thank you. Sorry, I probably shouldn't have done that motion just yet. Okay. So motion to approve the exclusive right to lease listing contract as amended, as advised to amend section 17 and section 25. I don't know if that was a good motion.
Okay, and we have a
You need to
second.
redo that motion, Melissa?
No, that's good.
But
Okay.
Do we have a second?
Second.
Okay, David, any discussion?
Indeed, commissioners. Casey, I have asked to unmute you. If you should be able to unmute yourself now and address the commissioners.
And Casey, before you give your comments, let me read kind of the stock language that we have for public comments.
Okay.
At this time, we will start the testimony phase of the hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing, if applicable. Finally, please limit your testimony to only the proposed new or modified forms and do not duplicate testimony. Should the commission or any of its representatives have a question regarding your testimony, we will ask when you have finished your testimony. If you desire to provide testimony, please raise your virtual hand, but just keep in mind that you have 3 minutes to speak.
Okay, good afternoon. My name is Casey. I'm speaking today on behalf of Patrick Armbrust, Director of Armbrust Real Estate Institute. He is the director, licensed since 1979, having served as associate broker, supervisory broker, and new agent training director. The comment is related to the proposed elimination of section 5.3 of the exclusive rights listing contract and previous elimination of rule 6.3G. Eliminating 5.3 greatly endangers the public, particularly in the case of newer licensees, those licensed 2 years or less. In addition, it would be very difficult, if not impossible, for supervisory brokers to properly supervise in accordance with CRS 12-10-217 1R, 12-10-203 5CI, and 12-10-222 and Commission Rules 6.3 A, C, D, and E. Under Commission Rule 6.3D, high level of supervision, the supervisory broker is tasked with being responsibly available for consultation, providing an assistance in preparing contracts, and monitoring transactions from contracting to closing. These obligations by nature often demand confidential information to be disclosed to the supervisory buyer. Common examples include seller needing to reduce the sale price, including quick sale, motivation, such as short sale foreclosure, multiple offers, sellers or buyers upset and refusing to close, agreed upon repairs more costly than anticipated, and the seller does not want the does not have the money, and also contract negotiations. Section 5.3 allows this and many such discussions. Removal of 5.3 at minimum legally challenges these discussions, endangers the associate broker for improper disclosure, and does little to help the consumer, if not endangering them. The best protection for the public would be to retain Section 5.3 of the exclusive rights contracts and restores Rule 6.3G with the exclusion of the language found in Section 5.3, provided such supervising broker or designee does not further disclose such information without consent of seller or use information to the detriment of seller. If the supervisory broker has an existing competing client, they could certainly delegate to the supervision of a non-competing licensee. In the rare case of bad actors, such as supervisory broker who uses the confidential information to the detriment of the seller, sanction that broker and preserve the ability to properly supervise for the industry. Thank you.
All right. Thank you. David, do we have any more discussion?
Yes, we do. Mr. Peterson, I have selected to ask you to unmute here, and you should be able to address the commissioners.
Yeah, thank you, Mr. Donnelly. Scott Peterson on behalf of the Colorado Association of Realtors. Also speaking in opposition to the removal of paragraph 5.3 from this exclusive right to lease listing contract, as well as the next three documents you'll be considering, the exclusive tenant right, exclusive buyer right, and exclusive seller right. The removal of 5.3 is a very significant change and a removal of a provision that has been in the contract for many, many, many years. You all are very familiar with this issue, I would imagine, as you spent the last or the better part of 2 hours already this morning discussing issues related to this in 6.3G. The removal of this and in connection with the revamp of whatever may come of 6.3G is not good for consumers. Specifically in the sense that brokers require supervision. It's not good for broker associates who need to be supervised in many cases, not good for brokerage firms who are the actual parties to these contracts, these listing contracts with the consumers. And it's not good for supervising or employing brokers who are charged with the regulatory as well as civil responsibilities to actually supervise their broker associates. What you may have heard this morning in your executive session was that this conflicts with Colorado Revised Statute 1210-403B6B, excuse me, and which has as well been on the books for nearly 30 years, I think. And so 5.3 as well as 1210-403-6B have resided in unison for many, many years. And I'm surprised that it's just finally coming up as a point of concern for the attorney generals. If there's any cause for concern to be had to begin with. What I would encourage in lieu of essentially neutering the ability of employing brokers and brokerage firms to supervise their broker associates by removing 5.3 from the listing agreements, that the attorney generals and the Division of Real Estate work with stakeholders in the currently ongoing sunset review process to encourage the Colorado legislature to make modifications to 1210-403B6 to incorporate the ability of a supervised broker to share confidential information for the purposes of supervision with their employing brokers, and moreover to make more robust potentially any penalties that may be had for employing brokers that use confidential information that's garnered in their supervision of a transaction, to penalize them in a more severe manner as may be appropriate for that completely inappropriate behavior. Thank you for your consideration of our comments.
Thank you, Mr. Peterson. Chad Oshner, I will be selecting you to, you should receive a request to unmute, and you have 3 minutes to address the commissioners.
Yes, good afternoon, good morning still. My name is Chad Oxner. I'm the employing broker for RE/MAX Alliance. Each year, our brokerage has the privilege of assisting more than 5,000 Colorado families buying and selling real estate. and this is a responsibility we take very seriously. We're committed to ensuring every transaction is handled with the highest level of professionalism, compliance, and care. I want to speak today about the potential change or removal of 5.3, particularly in the context of employing broker supervision and confidentiality. As you know, real estate transactions are not just business deals, they're deeply personal life events. As employing brokers, we're tasked with supervising designated agents who handle delicate and often complex situations. Sometimes very personal and private situations regarding motivation for selling or buying. Some examples, whether it's an aggressive pricing strategy for a seller desperate to move, a difficult, contentious divorce, or helping family sell their aging parents' home under a power of attorney. These scenarios require thoughtful guidance and supervision. To do that effectively, we must sometimes be privy to information that is confidential in nature. This is not about violating client trust. It's far from it. It's about ensuring our agents are acting ethically, legally, and in the best interests of their clients. And it's about protecting the public. Additionally, we are responsible for reviewing every transaction file to ensure compliance with the Colorado Law and Commission rules. If Rule 5.3 is changed or removed in a way that limits or prohibits employing brokers from accessing necessary confidential information, it could significantly hinder our ability to supervise, advise, and support our agents appropriately. In practice, it's simply not feasible or practical to provide meaningful supervision without this access. Doing so could lead to increased risk for consumers and undermine the very public protections that the Commission is tasked with upholding. I urge the Commission to consider the realities of our role as employing brokers and the safeguards already in place to protect client confidentiality. If one person violates confidentiality that causes harm to a transaction and the public, then discipline that individual. Any revision to Rule 5.3 should preserve our ability to supervise effectively while maintaining the trust of the public that we serve. Thank you all for everything you do and for your time and consideration.
Thank you, Mr. Oxner.
Quick point of inquiry. Since we're probably going to be getting a lot of similar questions, are we able to at least address that particular section?
So commissioners, I don't think the removal of 5.3 hinders someone's ability to obtain informed written consent from their client to share confidential information with their supervising broker. You're just going to be providing them more guidance through a rule of the threshold that needs to be met to achieve informed consent. So this is separate from the 6.3G rule. And based on the legal advice that you got this morning, this language is extremely problematic, not just in conflict with your statutes, but it puts the Real Estate Commission at risk with the Department of Justice and the Federal Trade Commission for being accused of colluding with the industry against consumers.
Yeah, I just wanted to kind of address that this is being addressed. I don't know how much I can say about that, but it is being addressed, and it has been discussed amongst the commission. So I don't know if that answers that question, but
Thank you, Commissioner Sanders. We do still have a few more hands here. If Keith Alba would like to address the commission, I ask you to unmute.
Yeah, hi, good afternoon, commissioners, and to save time, I definitely will not repeat anything that has been stated, but I do wanted to say that as the employing broker of Keller Williams Advantage, I have serious concerns about the removal of 5.3 from this listing contract and all of the other ones that you'll be dealing with today. I understand that there's a proposed something that's going to be coming out with some guidance in the future per Commissioner Sanders' statements, but My reality as a supervising broker is there is confidential information that is going to be contained within these listing contracts, whether it's automatic price reductions or adjustments or motivating factors that the seller has shared with their listing broker. If we're removing this permission here from my associate brokers from sharing confidential information from me, I'm not sure practically how I can review a contract for the completeness and competency until after the closing has happened and it's gone and in the past already. It's a challenging situation. It definitely is putting the consumers at risk. And there are certain things that can come up prior to a closing, like, the applicability of the Colorado Foreclosure Protection Act, or potentially an elder who is being coerced or forced into the sale of a property that they're not interested in. If I can't have those conversations with my associate brokers and put some stopgaps in place prior to a closing actually happening, then there's some potential serious concerns that that we're putting the consumers in serious jeopardy that's out there. So I thank you for your time, and I hope those were all addressed as part of your executive session.
Thank you, Mr. Alba. Mr. Cox, Damian Cox, I have asked you to unmute if you'd like to address the commission.
Yes, thank you very much, Mr. Donnelly. I am going to first start with something else, and before I get to my opposition of 5.3, and I don't want to rehash all that as well, but one of the concerns that I've noticed going through these forms that were noticed by the Division of Real Estate prior to this meeting is that your new forms process, I have concerns as to how it's working. Now, for you commissioners that were not on for the old forms committee process, this is something that's new that just occurred this year. In the past, there was 20 different people, collaboration and consensus that was usually reached amongst the forms committee that was then put together and packaged, and those forms were what were presented to you for approval, just as the ones that are being submitted to you today. The new process doesn't have that stakeholder input. It doesn't have that stakeholder advice. The people that are on the forms committee serve at the pleasure of the commission, and they are ranging from attorneys that represent buyers and sellers to attorneys that handle E&O claims to brokers that have geographic competency across the entire state. And this year's process, there was only 2 forms committee meetings. And what happened is half the forms showed up in the first committee meeting. They were given comments, and then the second half showed up in the second meeting. None of the changes or advice or anything that happened after those or the suggestions that were made were sent back to the forms committee to discuss any further. It was just those 2 meetings. And several of the things that you have in here today, or many of the suggestions you have in here today, never even went to the forms committee, which means that a big, vast stakeholder group of people that you appoint to serve and give advice on these forms didn't have an opportunity to even weigh in. And one of those is 5.3. And I'll tell you what the forms committee ended up with on 5.3 was originally was check boxes. And so this is the first time that any of us are hearing that the AG has concerns about informed consent. I tend to disagree. This law has been in place for 30 years. There's never been an AG, a judge, or anybody else that has said that they didn't have consent until now. So I'd love to see the legal authorities where that's coming from. But at the end of the day, they do consent by signing a contract. They are deemed to have read all the contract. But what was put before the forms committee was at least halfway decent in the fact that it had check boxes. At least when you have check boxes in the form, at least you can check the box that says that the seller acknowledges that they have the ability for confidentiality. By taking it out, you are completely putting broker associates at risk because the broker associate is the one that the new interpretation of the statute is deeming does not have the right to share that information with the employing broker. And that just doesn't make sense from a supervision level or high level supervision, or even trying to get advice as a broker associate. One other thing I will say, Commissioner Sanders, homeowners, you are correct that another thing that was missed in by not having this process of going back to the stakeholders is that homeowners was changed to owners a long time ago for the purpose of commercial transactions. And so there wasn't this misunderststanding. So I'm glad that you guys—
Sorry to interrupt, but your 3 minutes is up. I would
done.
like to point out that this is not a forum to voice complaints about how the new forms process has gone. It was collaborative. It was not managed the same way in the past because there were issues with how it was managed in the past, commissioners. We plan on discussing the future of the Forms Committee at the October meeting, but it was collaborative. Melissa incorporated their comments. She actually sent these forms to both Damien and Kent for further review before they were filed with the Secretary of State. So just to give you kind of that input, this was not a completely one-sided process on the division's part.
Thank you again, Mr. Cox, for your comments. Paul Hunter, I have asked you to unmute, and you have 3 minutes to address the commission.
Okay, thank you. I appreciate that. My name is Paul Hunter. I am the employing broker for the Group Real Estate in Northern Colorado. I manage a little over 200 agents. Have been an employing broker for 15 years and also manage 4 designated supervisory brokers for our separate offices. And I also want to speak about 5.3. I'll try and give some different perspectives so as not to reiterate everything that we've talked about here already. Increasing the skills and knowledge for our brokers that are serving the public has been a large focus for the majority of my career. And I believe that the removal of Section 5.3 and all of the listing contracts, including this one, will hurt our ability to effectively manage those broker associates. And ultimately what that means is it will be detrimental to the public. We've talked a little bit about new agents here, maybe being the biggest risk to the public if they're not being managed effectively, and along with our responsibilities to you as at DORA of the high level of supervision, but to experienced agents as well. And being able to be a sounding board for these ideas and manage them through the best supervision and advice for our clients. Our managers and myself, we answer countless questions. I mean, it's between 10 and 20 and sometimes more transaction-specific questions per day. And if we are unable to understand all of the dynamics of each of these transactions, then we won't be increasing the knowledge and experience that is a direct benefit to the public. I'll echo what somebody else, a couple of other people had said here, is if any of that confidential information that is being given to an employing or supervising broker is mismanaged or used improperly, I am a big advocate for punishment for those people if they are breaking rules that do hurt the public. So hopefully this perspective brought a little bit more to the conversation, and I really appreciate your time today.
Thank you, Mr. Hunter. Katie Keeker, I have asked you to unmute, and you have 3 minutes to address the commissioners.
Thank you. My name's Kate. I'm a large employing broker of a large brokerage firm of over 450 agents. And the removal of 5.3 is certainly something I want to address. And although I share the same sentiments as what has been brought forth, I think it does speak to a level of concern many of us have and the attention that this truly deserves. It leaves questions and concerns that I would just like to address. And I don't want to rehash or mirror what everyone has said, but I do want to bring these same things up because it's that serious of a component to be taking out. As an employing broker, one of the questions I have is how would we be supervising a transaction if we cannot have access to the files? If an agent is calling in, as stated before, with questions or needing guidance, yet we don't have the full picture in how to advise them, it's not only a detriment to our agent and our brokerage firm, but it's a detriment to the consumer as well. At our brokerage firm, we have a rigorous program in having files uploaded early in the transaction so that we can review things throughout the transaction and oversee what is going on. There are times I have to intervene, but this process allows us to be overseeing this as it goes so that we can be proactive and not reactive when it's too late. Furthermore, I have a question of what happens when a consumer calls in to the managing broker with concerns about their agent or concerns about the transaction. Yet we as managing brokers cannot access the file or really intervene in a proper manner. The division is supposed to be a consumer protection agency, yet this could be harming the consumer, not just the brokerage firm. I also have questions about how the division will investigate when the consumer has a complaint, or what happens when we're named in a lawsuit. It leaves a lot of concerns that really need to be considered in just taking out 5.3 in any of this. It doesn't seem like the division has thought this through from every angle, and I think it'd be a difficult thing to reverse if it gets approved. I appreciate you deeply considering the implications that this could have, commissioners. Thank you for your time.
Thank you, Kate. And I believe I called you Katie. I apologize about that.
Oh, that's fine. Thanks.
One additional hand that I see at this time, commissioners, is Kelly Johnson. You have 3 minutes, Ms. Johnson.
Thank you, David. Hi, everyone. Thank you for the opportunity just to briefly comment. Certainly, my name is Kelly Johnson, and I'm in-house counsel for Liv Sotheby's International Realty. And I'd really just like to take a brief moment and not rehash what we've already heard. I know that this has been a topic of frequent and careful conversation and discussion. But I do echo the concerns voiced by those that have shared their thoughts before me around deleting Section 5.3 in the 4 listing contracts. And just for some additional context, our brokerage has about 500 brokers, 10 designated supervising managing brokers, and we've closed approximately 7,000 transaction sides since January 1 of 2024. And I share this really just for a glimpse into the fact that we have had the privilege of working with a fair number of consumers on their transactions. And so, as everyone else has stated, I respectfully request that the Commission really reconsider the deletion of Section 5.3 and ensure that the listing contract does include a mechanism for sharing that confidential information between the broker and the supervisor in order to really facilitate the duties of both of them and for all the benefits to the consumers that have already been shared. And I think if what I'm hearing is that the decision may be that there needs to be a more specific informed consent, I don't know that a rule or position statement will be enough. Consumers, I think, will really benefit from having a uniform clause that facilitates this informed consent. And I would respectfully suggest that it makes sense to continue to have that in the listing contract. Certainly, as everyone else has shared, nearly every day we have our supervisors really being asked for guidance regarding the client matters. And in order to offer that guidance and to oversee the transaction, we have to allow the broker to be able to share certain confidential information with their supervisor. And supervisors understand that they have to honor the confidentiality, and if others have suggested, they should be disciplined for their failure to do so. But I think if this information sharing cannot happen, the supervisor would really be overseeing the broker without any real context for the issue at hand. And not only is this a disservice to them and to the broker, it's most importantly a disservice to the consumer. And I'll also add, in those nearly 7,000 transactions we've had over about 18 months, not once has the sharing of confidential information between broker and supervisor been an issue. And this is true even where in approximately 25% of those transactions, we have brokers on both sides of that transaction table. But I would suggest that on the other hand, by deleting 5.3 or language similar to 5.3, the sharing of confidential information is not facilitated. There's not a uniform way for the consent to be obtained. And this fact alone, I think, would very likely create issues for the reasons mentioned. Thank you for your time and consideration and all the hard work on this topic.
Thank you, Ms. Johnson. Commissioners, with that, I do not see any other hands raised at the moment. That is correct.
Okay, thank you, David. So based on the comments that were made, I do have some concerns with removing 5.3 as well. The problem is that a contract is considered confidential information. And if you cannot discuss the contract itself with someone, with your supervising broker, how are they going to supervise you? And also it did come up, I hadn't thought about it honestly, the files all your broker files that are supposed to be kept for 4 years, if we don't have this in here, nobody can look at them and do this. So honestly, there's some things in here that we hadn't thought about or discussed, because this is actually pertaining to the contract and the file. It's not pertaining to, I have to sell this in 5 days and I'll take 10,000 less. That was more what I was looking at previously, was confidential information like that. But the fact that a contract itself is confidential information does lead to lots of issues that are going to happen with supervision and with holding on to these files. And I'm not sure what fellow commissioners are thinking, but I actually was not thinking about those items. And with the information that's been presented, this actually makes me pause and think that this is going to create an issue. Anybody else?
You're muted, Erica.
Thank you. I actually felt in our executive session, we discussed a lot of what came up today. A lot of those things were brought up. A lot of those things were shared concerns. And really it's about, it's the things that were brought up just now, we definitely understand. But that to me pertains to the rules and things like that, versus this is the contract and what needs to be in the contract versus what we're going to do in regard to 6.3G. And I think that, again, a lot of the testimony today was already discussed and already addressed. And I don't know how much I could say about that, but I think the question of matter is, what needs to be in the contract? That's the question.
The problem is, if we take this out of the contract, we are going to have each person who signs a contract sign, if we're doing this separately, sign a separate informed consent disclosure. And it won't be an option, because everyone will have to sign it in order to discuss it with, as far as supervision, and in order to have the file on hand at the company, which we require. So that's the problem, is that this contract is considered, confidential. And because of that, we've got a problem now. It's not just informed consent so you can discuss something with a broker. Every single person's going to have to sign an informed consent form in order for us to keep these files or have someone review them, which the files are supposed to be being reviewed by someone. And so if it's going to be an automatic, here you have to sign it, does it actually hold as much weight? Is it as important? Because now it's one more form they just have to sign, and you've got to sign it regardless. It's not, we have a question and I need you to discuss it with a supervisor, so I'm going to sign this. It now becomes every single person's going to have to sign this form in order for someone to review the files, or, this is,
well,
I don't know. I almost think that a separate form now is just another form to sign. It's not giving it any weight. Whereas if we keep this in here, this actually gives us the ability to discuss with supervisor. You're not discussing personal information. I know we talked about making, the informed consent a separate rule. So we're explaining to people what is going on and what the consequences are. And maybe we can modify this 5.3, but if we're just saying we're taking it out totally, I think there are going to be some problems. So maybe we need to modify 5.3 if there's some direct concerns, or we leave it alone. But
and I partially disagree, because I do think that this contract will probably need revision again at some point, because if we're talking informed consent, I don't see why that isn't something that could be put in the contract.
But we were
Just for
talking
those
about
that
doing
raise,
together.
I mean, just for those of you that raise questions and concern, as I mentioned before, we had a very in-depth conversation addressing a lot of the same concerns. There's not a easy one-size-fit-all fit, right? And so we're trying to address this in a way that allows for that supervision and, you know, all of that, but also trying to figure out how to do that in a manner that doesn't conflict with, you know, statutes, right? So I do agree that that what we discussed in our executive session can maybe be part of this contract, possibly, versus the language as it's presented here, because I think this is in conflict too with what we discussed in executive session. So does this contract need work based on what happened today? Yeah. And maybe it's a situation where we don't approve it right now. But I don't think that 5.3 fits in the box properly. But I do want everyone to, you know, on the call that raised concerns to understand that as a commission, we also understand those same things. So I want to kind of settle the room on that point. But to everyone's point, this may not be 5.3. I think it does need to be removed, but it may have to be revamped or something. That's my comment.
So if you take it out, nobody can look at this form, right? You aren't, you know, you're not giving consent so anyone can look at this form that's in the real estate office is what I'm talking about now. I know what we talked about before, and that was one thing, but honestly, I didn't think about this part of it. You can't now have someone look at the contract. You can't file it. You can't have someone look at it. I don't know. This brings up some different questions.
We have to remember that this is related to managing and supervising brokers too, right? I don't know. I guess I don't have the answer to that. I'm not sure legalities if it couldn't be filed, the contract can't be filed.
Someone has to look at it.
With the language that we are proposing, that we propose in the executive session. So
But if you take this out, then how do you get, no one can look at this ever again, basically, you know, no one outside who's part of this contract. Is kind of odd. So then everyone would have to sign an informed consent form if we're doing that, so that you can look at this form and file it and keep it on record. Otherwise, no one can ever look at it. It's kind of an odd situation.
Unless that is part of the contract.
Can I jump in for just a moment? I know that we made a lot of discussions this morning, and I want to just say, yes, we touched base on almost everything that was brought up this morning, which is why that executive meeting took so long. But you guys did bring back some excellent points, again, that we will continue to consider and discuss. I think that we are jumping the gun on removing 5.3 because we do not have the fixes in place for what was suggested this morning. Those are not there yet. So I think that if we were to remove 5.3 today, that leaves everything way open. My suggestion would be to leave 5.3 there while we continue to work on the suggestions for this morning and see how that pans out, because that is not even remotely done. And then go from there, because that can be corrected later. 5.3, we can make that better. But it's not there. We should not be removing it. The suggestions that came up today are a lot of what we discussed, but some additional things that were not contemplated.
So commissioners, just to point something out, these forms, if you approve them today, they go into effect January 1st of 2026. We can get an informed consent rule in front of you for rulemaking by October to have it in play when the form goes into effect at the beginning of January, along with position statements.
I would still not be comfortable, I think, saying that I'm okay with removing 5.3, not knowing what we're doing in the future, for sure.
I agree, Erica. I think we should leave it in for right now, and when we get other language or other things that we're going to approve, then we can revisit this. We could agree to the other changes in the form for right now, but we could, not agree to that one until we get other things in place.
So
Agreed.
may I ask real quick though, are you saying in October we would be reviewing this form potentially again if we didn't vote on this today?
Well, if
Is
you
that
don't
what
adopt
you're
this
saying?
form, I mean, we're not going to beat a dead horse and bring it back again for the same argument in October. What I was
Okay.
saying was if you adopt this form with the removal of 5.3, we'll have an informed consent rule in front of you for rulemaking in October so that the rule can go into place the same time this form goes effective, January 1st of 2026. We can also work on the position statements and getting those in place as well.
Yeah, but if we don't have an agreement on that rule yet or the position statement, then we've removed 5.3.
But you can't have a statement in your contract that contradicts the license law.
But we
This does not
have
allow
for
for
30
informed
years.
consent. Well, that has been one of the problems that we were going to discuss with you at the October meeting, with some of the issues that we've seen over the years with how the forms have been managed.
Well, and I agree. I mean, I am not disagreeing that we need to repair this and we can make it better. I'm not disagreeing with that at all, but I think we've got the cart before the horse on this particular one.
So my understanding is that the statute stands that confidential information can be discussed from the supervisor or managing broker. That's the statute. So if removing this doesn't remove the statute, maybe we could discuss that. Am I incorrect in that?
Commissioners, without me disclosing the confidential advice that was given during executive session, I don't think I can go too deep into discussing that in public, but I just want to highlight that I'll stand behind everything that was stated by me during the executive session. The language in 5.3, it is Attorney General's, our office position that is problematic in terms of informed consent, and the law is such. There are two sets of statutes currently in existence, one that requires supervision and one that outlines that certain information, confidential information, can be shared only after obtaining an informed consent. And so we discussed that issue, and I agree with Director Waters that we have a solution. We talked about the solution, but the language 5.3 is problematic.
And am I correct that it doesn't remove this isn't, I guess what the point I'm trying to get across is that you still can supervise and manage. That doesn't change with it.
Absolutely. Removal of this.
With it not being here doesn't change the fact that you as a managing broker can supervise your brokers in instances where confidential information is shared. There's obviously some considerations you probably should make, and those are brought up as well today before supervising those double-in transactions, for example. But it doesn't take away the statute. So just removing it from the contract doesn't mean that now all of a sudden a managing broker cannot supervise their brokers and provide that and share that confidential information. It's just saying that there's a consent that needs to happen, which I'm hoping can kind of be addressed in the contract at some point. But correct me if I'm wrong. That's my understanding.
Right, you're absolutely correct that removal of 5.3, if the commission would like to move that decision, doesn't change one's ability of supervising their associate broker.
But does it give consent? Because this 5.3
This
says,
was not given a consent to begin with, Madam Commissioner. This
well,
is
but right
insufficient.
now, that's what it says. I know we're trying to change things, but right now this does say consent until we have something else in place.
But it's insufficient to meet the burden of informed consent. That is the problem, one of the problem with current language 5.3.
But it might be better to have this than nothing until we get the other things sorted out.
The law is still in place that talks about the need for before sharing confidential information, obtaining an informed consent, and the same way as the statutes requiring supervision is still in place. Nothing has changed in that regard.
It's just removing the vague consent request from the contract. It's very vague, whereas there needs to be a little bit more in-depth specifics about consent, what that really means, what that really looks like.
Right,
So
but we don't have that
this
yet.
is just giving kind of a blanket consent, which can also be abused, right?
Well, but we don't have the other, so I don't think the average consumer understands it, so at least there's something in there right now that it says they consent to it, and if the contract has gone over like it should be with the client, they would understand this. Otherwise, they're not going to know anything. So I think we should leave this in until we get the other.
But then it's going to be in conflict with what we discussed today, which
That's
is
not in
going to
place yet.
be at some point.
Right, but we can adjust this down the road once we get the other things in place and figure those out. You know, hopefully they'll be ready in October, but we have been messing with a lot of this stuff for a year and a half. So there's no guarantee it's going to be done in October. So I would say it's better to have something that says consents in there right now so that at least the client would see that and have some understanding until, you know, if we get everything done in October, we can revisit this.
Madam Chair, would it be helpful to hold another executive session so I
No.
can reiterate my advice?
No. I
The language is problematic as written.
I understand it's problematic as well, but I'm just asking for a delay on this one until we have the others resolved. And I think that's a good point that Renee brings up on it, is that we have been dealing with this since before I was on here. And if we all make it a priority, we can get through it quicker, but I would say leave this in until we know exactly what's happening on the other, and then we can go back and make sure this is accurate.
Would it be a solution to table the form, all the forms that have 5.3 removed to October, Director Waters?
I don't think that's a problem. And Irina, I would like to know if your office can provide us with some legal advice about what happens if the Real Estate Commission decides to adopt policy that appears to be collusion with the industry for the Department of Justice and the Federal Trade Commission versus the division. Like, is the division then assuming that risk? So just as an aside, but yeah, we can table the listing contracts until October. But I think we also need to evaluate the risk to the division at this point.
I think it's a good idea to table it until we have more substantial information regarding, 6.3. So if that means we'll have that before October, and then I don't know if we are able to review that ahead of time or something, but I'm not actually comfortable with the information and the legal advice we got today. I'm not comfortable keeping this as it is either. So 5.3 as it's written doesn't work to me based on what we discussed earlier. And then we don't have the other things in place, as an alternative. So I think it would be appropriate to just table this for the next meeting. And I know it's beating a dead horse. I'm just getting in on this since April. So
as long as you guys are making a definitive decision in October, that's fine. Do you want to table all of the listing contracts and then Melissa can just start up with the forms that follow after that meaning the seller association authorization.
Yes.
I
Yeah.
think we have to because we're not in agreement. So I
Yeah.
think we have to.
Do we need to make a motion to do that, or are we okay just doing it?
I think it'd be helpful if you did a motion to table the listing contracts until your October meeting.
Okay, someone want to make a motion?
A motion to table review of listing contracts until the October meeting.
We have a second.
Second.
Okay, any discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes to table the listing contracts.
All right, I'll move on to the seller association authorization, but I'll just give David a second to catch up so he can, oh, there he is. All right, this one's a pretty easy one. The first proposed change is to add address after property. Pretty self-explanatory, just for clarity. Added the S after sellers to include the possibility of there being more than one seller. The word establish was changed to initiate throughout the form. And there was a change made pertaining to paragraph 1. The previous heading actually only applied to paragraph 1, but it was over all 3 of the paragraphs. So that heading was just kind of incorporated into paragraph 1. And then in paragraph 3, the term fees was changed to cost for clarity's sake. And that's all I have for you.
Okay, any discussion?
No, I didn't have any.
All right, someone want to make a motion?
Motion to approve the Sellers Association authorization form.
We have a second.
I'll second.
Oh, excuse me. I jumped the gun there. I apologize.
All right, David.
Thank you, Madam Chair. Any members of the public, please click the raise hand icon if you have any comments on this form, the seller authorization or seller association authorization. And seeing none, commissioners.
Okay, then we'll take a vote. Any further discussion? All right, all those in favor?
Aye.
Aye. Any
Aye.
opposed? Oh, any opposed? Nope. All right, motion passes.
Okay, then next form on the agenda is the seller's property disclosure. And while David's getting that up, as an initial matter, I just wanted to note that the past practice at these non-rulemaking hearings has been for all of the changes to the seller's property disclosure to be discussed in the context of the residential version of the form. And then after those changes have been approved, division staff will go back and make the conforming changes to the other versions of the seller's property disclosures. It's done for efficiency so that we don't have to discuss the same changes multiple times. So after your discussion of the proposed changes, when you make a motion regarding the adoption of the forms, we'll ask you to delegate authority to staff to go ahead and make those conforming changes to the seller's property disclosure, commercial, land, and the supplement for additional structures. So I know that looking at the red line version of the SPD, it looks like there's been a lot of change. However, there hasn't been a lot of change to the substantive material, but rather most of the redlining reflects a change to the way the form is structured. The order of the information within each topic has been rearranged so that the information is now presented in the order of general information, then if the seller knows of any problems now existing, and then if the seller knows of any problems ever existing. And additionally, the proposed changes are made with the eye for an attempt to provide more detail regarding the type of information sought and to provide more detailed prompts to help the seller provide accurate and relevant information. So moving on to specific proposed changes, In the introductory paragraph, most of the changes are just for clarity and ease of reading. There is a substantive change in that the current version states that if the sales contract requires seller to complete the SPD, it must be fully completed to the seller's current actual knowledge as of the date of the contract. And this was mentioned in one of the previous contracts that we covered. The proposed change is to make the requirement that the SPD be completed to the seller's current actual knowledge as of the date of the seller's property disclosure deadline. That's in the contract. Also in that paragraph, the broker, I guess the next paragraph, broker's ability to deliver a copy of the SPD is changed from may to is authorized to. A statement regarding seller and broker's knowledge that the SPD is not a warranty and that an independent inspection is available and advisable was moved from the end of the contract to this introductory page. Hopefully, the intent is that this will provide the proper context of the purpose of the SPD as a whole to the reader before they begin their review and filling out the document. Proposal to remove the note as it wasn't deemed to be necessary to be there. Date was clarified to read date SPD completed by the seller. There's a proposed change to allow seller to provide additional information, whether seller is currently occupying the property, if the seller is not currently occupying the property, the date on which they last did so, and the status of the property during any period in which seller was not occupying the property. And the note at the bottom of page 1, the proposal is, it's not just to be deleted, it's just to move it down under the next heading. So then moving on to section A, additional details were added in regarding the specific building conditions that are being inquired about. In section B, that shows that change that I mentioned to have the general information first. And then also the language regarding the general information was just changed just to clarify it and add a little more detail. Section C, additional details are requested about the appliances that are on the property. Section D, again, you'll see that change to have the general information come first. And then there are additional details that are more explicitly sought about kind of the already existing areas of inquiry. There's just more detail sought now. Section E, again, orders change that general information comes first. And again, more additional details are sought, such as the type of furnace, number of units, whether it's zoned, the type of fireplace or freestanding stove, the type of air conditioning, the age, whether it's zoned, and the number of units. Just more detail about the existing areas of inquiry. Moving on to section G, again, the general information is now first, and greater information is sought regarding each area of inquiry. And the information is maybe hopefully requested a little more, what information is being sought is stated a little more clearly. Now there is an additional change that's highlighted there that is not on the version that is presented to you before the meeting. And this is something that we were unable to get wrapped up prior to filing with the Secretary of State. There was significant discussion at our Forms Committee meetings where the Forms Committee discussed if the SPD should be changed to include more detail about the type of well that is actually on the property. Despite that discussion, there really couldn't be a consensus reached about what to include. So the recommendation from the Forms Committee was to seek the help of an outside attorney that is a water law expert. We at the division did seek out an attorney with expertise in the area of water law. We had several in-depth discussions with her. She provided us lots of valuable information about what she believes is relevant to put in here. And this is what we came up with, which details information about the type of wells that are most likely applicable to residential properties. So that's that additional information if you guys want to take a look over it. We did gather other information about different types of wells that the water law expert thought were applicable to either commercial properties, which we can add that information into the commercial SPD, and then also wells that were related to more rural properties, and that could possibly be incorporated into the SPD for land. The other addition to this section G is a new question which asks if the water has been tested for potability, and if so, asks for the results and any records and reports related to that testing. Okay, so moving on to section H, the primary change is changing attached to provided. Since it's not always possible to attach documents, this change makes it clear that it's acceptable to provide the documents by other methods that doesn't have to be actually attached to this document. Section I contains the same change, removing the general information first. It also contains new, more detailed inquiries regarding the septic system. Section J adds in more areas of inquiry. Proposed revisions also ask about any grading issues, water intrusion in the property, repairs made to control water intrusion, and whether there are dams, stormwater detention basins, or other similar facilities. Section M just adds the proposed to add examples for clarification purposes. Section P, that change existed to existing to include any current issues. And then in P also contains the common interest community association. That's that section. So there was a proposed change from owners to homeowners association. That wasn't objected to by the forms committee upon their review, but based on the commission's guidance from earlier in the meeting, I will go ahead and make all changes back to owner rather than homeowner. And then section Q, this is a new section which provides a place for the seller to disclose whether the home is located in a metropolitan district, and if so, provide the name and official website address of the applicable metropolitan district or districts. Section R adds in several new areas of inquiry, whether there have been any investigations or studies regarding mold, whether there has been any litigation alleging negligent construction or defective building products, and whether there has been any award or payment of money in lieu of repairs due to these issues, or if any liability limiting release has been signed regarding these issues. There's also a proposal to add in a request for seller to provide copies of relevant reports in their possession and for information related to U.S. Postal Service delivery to the property. And then that paragraph regarding the inspection services, as I already covered, has been moved to the beginning of the form. There is a proposed addition of a paragraph related to other known adverse material facts. This is intended to be a catch-all for any other material facts known by the seller that for some reason didn't fall into any of the other explicit categories already listed on the form. And then the proposed deletion of the advisory to seller paragraph. The reasoning for deleting this paragraph is that since this is a disclosure document between the seller and the prospective purchasers, it's not the relevant place to be determining a broker's obligations. And then finishing out the document around the signature block, there's just minor changes. Again, changing seller to the possibility of being plural, since there may be more than one seller, and adding the word complete to clarify that the relevant date is the completion of the form. And then again, only minor changes under the advisory to buyer, deleted item number 5, because that's already stated previously in the document, and the proposal to delete item 7, because there is a proposed addition of an acknowledgement line above the signature line that incorporates what was stated in number 7. So that's all I have for you. I'll turn it back over to Commissioner Lind.
Okay. Anyone have any questions, discussion?
I just wanted to address the individual that sent in potential revision to be considered. It looks like it was in there. So
Yeah.
that individual just wanted the website of the Metropolitan District to be listed, which was. And then the only other little quick small note that I had was under doorbell. I think it would be good to address rather well, I don't know, it's in the contract, but whether or not the Ring doorbell, goes or we'll say video doorbell. I don't know if that's something that anyone else feels is necessary, but that was really the only other note that I had on here. It's very detailed and lengthy, but
Yeah.
At the end of the day, I guess more disclosure is better than less. So,
Would it be helpful, Commissioner Sanders, if we just put in like a checkbox for maybe whether it's hardwired or if there's a video doorbell, just kind of breaking
I
it
think
out a little bit
so.
more?
If anyone else on the, any of the other commissioners feel that that would be helpful, if not, not a big deal.
It could be helpful. We just see them so frequently. So,
And there's
yeah.
sometimes confusion when people keep them. So
Yeah.
I think it's good to just put it
On
on.
that note, there was also something in there about a fireplace starter, which I thought was odd. Are you looking for switch or remote or, turn it on in the unit? I was just kind of, what are we looking for there?
That makes sense. I mean, I'm thinking of like my home. I have in one of my fireplaces, you can only access it through a remote. There's
Yeah.
no switch.
There's
So
remote,
that's
there's switches, and then there's usually the little dial.
Yeah.
If you lift it up, is that what we're looking for there? I just didn't know what fireplace starter meant, if that's what it means.
Have the line reference. I'm sorry, I'm not seeing it.
I didn't write down the line.
But I can certainly go back and, oh, there we go.
Yeah, it says fireplace starter. Whoop, it just went away.
I think I saw it.
Yeah.
I was looking for the section by scrolling up there a little bit, commissioners. I apologize.
Anyway, there's.
So clarify, like if there's a remote that goes along with the property.
Right,
and
what are
whether it's
we
working.
looking for? I mean, if we're gonna do the doorbell thing, we should probably do something here with, switch or remote or knob.
Okay.
So. All right, anyone else have any other discussion?
One in section I under sewer. You can go there. I'm just wondering about the title on that, since so many remote areas are septic. If we would contemplate changing the label as sewer/septic.
Yep, that's a good idea.
Okay. I made note of that.
And then we took care of the other one for owners association throughout that, and okay, no, that was my only other comment on that one. Thank you.
Okay, does someone want to make a motion? We need a motion that includes the other forms as well. I don't know if you remember, or I can do it. I wrote it down.
Oh, yeah, if you wrote it down.
Yeah, okay. I motion to approve the seller's property disclosure and to designate division staff to make the corresponding corrections on the commercial land and supplement additional structure disclosures as well.
Second.
Okay. All right, David, do we have any discussion?
We do indeed, Madam Chair. Mr. Damian Cox, I have asked you to I asked you to unmute. You've got 3 minutes. Thank you.
Thank you. I will make this brief, commissioners, because it's been a long meeting for you. On the first thing, after hearing Director Waters' comments about my testimony previously, I feel like I probably owe Ms. Phipps an apology. I did not mean by any stretch of the imagination to say, to imply that she somehow did a bad job. In fact, I think she did an exceptional job on these forms. And I just want to make sure that that's clear, that that my comments were directed more at the procedure than it is at her and her controlling the forums. I think she's done a fantastic job. The second thing real quickly I'll say is I'll commend you guys for pushing this off, and the 5.3 off until October. I'm hoping this rule that the Attorney General is preparing will alleviate a lot of the consternation in the industry and we can finally get beyond this issue. But my actual comment to this forum is at the beginning of the session, Director Waters mentioned something about an IP disclosure that was going on these contracts. And I guess my question is, and she said that they couldn't be changed or used that weren't conforming with the rules. Obviously, the rules apply to real estate brokers. And so I guess my question is that disclosure only going to be for real estate brokers, or is it also going to be or somehow affect attorneys and consumers that also use your forms? And I don't know if there's an answer for that or not, but it was something I did want to at least comment on. And that's all I have. Thank you.
Thank you, Mr. Cox.
So commissioners, the language would go on your forms. It would be applicable to everybody. And this is guidance from an intellectual property attorney. We want to make it clear that these are your forms and that not anybody can modify them unless it's within the parameters of your commission rules.
Okay, any other comments, David? Or
nothing else at this time.
Okay. All right, any further discussion? If not, we're ready to take a vote. All those in favor of the property disclosure and designation for other disclosures?
Aye.
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 Aye. Any opposed? Okay, motion passes.
All right. The next one on the agenda is the closing instructions. All right. So paragraph 1 changes contract to buy and sell real estate to the more generic contract so that it can be applied, so that it can apply to the various versions of the CBS. Second sentence, proposals to move it to a more appropriate location at the end of the paragraph, just for ease of reading. And the term agreement is proposed to be removed because it's not a defined term in the contract, and it has been replaced with the term closing instructions. In paragraphs 3, 4, 7, 8, 10, and 14, capitalization was removed from words that are not defined terms. And then there are some other non-substantive punctuation changes proposed. Going down to paragraph 9, there is a proposed expansion of the wire fraud warning to make it more detailed and explicit. And there is also a proposal to add a FinCEN notice to that provision. Paragraph 10, insertion of the word otherwise for accuracy. 12, just revision of language for clarity and assertion of language clarifying the conditions under which a title company is required to return earnest money deposits. Paragraph 15.1, addition of language that imposes an additional requirement upon the closing company requiring FERPTA compliance. 16, bolding of the additional provisions language that's been discussed previously. Paragraph 18, just addition of clarifying language. 19.1 and 19.3 is the same changes we've seen to notice provisions in other contracts. Just 19.1, adding additional paragraph reference for accuracy, and 19.3, deleting the word notice. And then finally, there's proposed addition of an acknowledgement line above the signature lines for all parties. Turn it back over to the commission for discussion.
Okay. Anyone have any comments or discussion?
Can you go up to 15.1 just so I can take a look at that again on yours? So let me just read that one more time. I was looking at that on mine versus yours. Sorry. I wanted to make sure we're not stating that they have to provide something that they're not able to do. And as I was reading documents earlier, I felt like I saw a conflicting sentence in this paragraph, so.
And I'll be honest with you, Commissioner Doyle, that was a sentence that was added at the suggestion of the Forms Committee, and it's kind of beyond my level of understanding. I just deferred to their expertise, so I'm not sure I can help you with any clarification regarding that.
I mean, that was my only thought when I read that, was that it just states clothing company agrees to provide this, which I think is reasonable if we were to add something on there that says, if backup withholding from seller is not required, clothing company agrees to provide this. Again, I just didn't want to have a statement in there that cannot be done if it's not correct. Thoughts? Did anybody read through that on that sentence?
And so you're recommending just add the word if? Am I right?
I think would it read, if backup holding is not required, comma, closing company agrees to provide buyer an executed affidavit compliant that states that backup holding from seller is not required, or you could say that confirms
Correct.
this.
Yeah,
Okay.
just so they can do it, but they're not every single time required to provide something, because if, you know, it wasn't required, they can't provide that statement.
I think that's a great point. Makes sense.
And I just had a clerical thing on line 20, the word contract. Shouldn't that be capitalized just to be consistent with the other words in the contract on line 20?
Line 20 of the first page?
Yes.
Yes, here we are.
Yeah, it just says contract. Should it be capitalized there? Because it's capitalized multiple other places.
Well, I think that goes back to an earlier point that was made, that it depends on each specific contract. It will be capitalized in some contracts because it's a defined term in that particular contract, and others it won't. I think the reasoning of leaving this not capitalized here was that just so it could encompass, because when you say contract to buy and sell real estate, it denotes a particular one, and this closing instruction could be used for any version of the contract to buy and sell real estate form.
Okay.
I did have a comment on 23, line 23 and 24. It's really a flow issue. When I read this sentence, it just doesn't, to me, seem to flow well.
Let's see, there's the word contract and it's capitalized, and the word contract is capitalized above it. That's why I was saying contract should be capitalized.
Oh.
Well, in the sentence, I'm speaking really just to the actual like full sentence. So the sentence, I'll try to read this as best I can here. In the event of any conflict between these closing instructions and the contract, these closing instructions controls subject to subsequent amendments to the contract or these closing instructions. I just felt like that flow. Is there a better way to say that without it's going into like circles? Yeah. It's not clear. I mean, I had to read it a couple of times just to put my brain around it. I think a more simplified way to say that, because really all we're trying to say is that if the contract and closing instructions are in conflict, the contract prevails, basically. But it's a very wordy way to say that and confusing.
Okay, first of all, sorry, Commissioner Sanders, if I can put a pin in that and go back to Commissioner Lyon's point. I understand what you're saying now. I apologize. I didn't fully grasp the point that you were trying to make. Contract to buy and sell real estate was changed to small c contract. Just that so it could be any contract to buy and sell. But then it goes on to say including any counter proposals and amendments, and that becomes the uppercase C. So any CBS and all counter proposals and amendments, that whole package becomes the uppercase C. And then that uppercase C is what is referred to throughout the remainder of that paragraph.
Okay.
That makes sense?
All right.
Okay. So now Commissioner Sanders, certainly open. I know some of this wording is kind of cumbersome, so I'm definitely open to any suggestions that you may have about how to make it flow a little bit better and be more friendly.
Yeah, that was really the only sentence that really just I'm sorry, I'm reading it again. In the event of any conflict between these closing instructions and the contract, these closing instruction controls, subject to subsequent amendments to the contract or these closing instruction. That doesn't even flow.
Commissioners, if I may, I can remove the red lines temporarily here so that because I think that there might be some challenge in that you're having to skip through some of the deletions. How about we do that?
I have it. I could look at it on my end. Am I the only one reading that as?
No, it's kind of fuzzy.
Like I said, not a big thing, but I mean, I don't really even. I don't feel that sentence is clear. I'm gonna pull it up.
It's like we need, because we've got closing instructions control, and then we have subject to subsequent amendments of the contract or these closing instructions.
Yeah, it's just too wordy.
So
we just need to simplify that a little bit to get the point across. Okay,
yeah.
I'm looking at the clean version now.
And again, the only change that was made in this round was just changing agreement to closing instructions. So, you know, I don't have any input on that sentence as it stands other than that. So I'll just defer to the commission of how they would rather see that worded.
Okay, I found it. In the event of any conflict between these closing instructions and the contract, these closing instructions control.
I guess, could there be an amendment to closing instructions? Because they're saying subsequent amendments to the contract or these closing instructions. Can you amend the closing instructions? So closing instructions control subject to the contract or the closing instructions being amended. I don't know if that's what that means.
Commissioner Sanders, do you just want it to say that the contract prevails if there's a conflict?
Yeah, that's it.
Because a lot of what we hear is that closing instructions aren't even completed prior to closing half the time.
Yeah, that I literally just something more simple to get the point across that that yeah, they prevail. So we can even say it that simply. It's just so wordy to say that little thing. So
just
is it possible to rework that? Or do you want us to provide you with the actual sentence?
I could definitely work on it, but I just want to be clear. Because as it's written, it says the closing instructions control, but I thought I just heard reference to the contract controlling.
It should be the contract controls.
Okay.
Oh, yeah, hold on. In the event of any conflict between these closing instructions and the contract, these closing instructions control subject to subsequent amendments to the contract or these closing instructions. The buyer's, so maybe are they saying these closing instructions control the contract? Either way.
It would be a very easy change to change it to in the event of any conflict between these closing instructions and the contract controls, or the contract and any contract amendments control.
Mm-hmm. Or prevail, yeah.
Prevail.
Yeah, that's really all
Okay.
I had. Actually, that's not all I had. I just, since it is kind of an important thing, I just feel that it needs to be a little bit clearer. And then, so I have that comment, and then my last comment, and I don't know if this is even something that can be added. This is just kind of something I've been noticing here lately. A lot of the title companies are refusing the seller statement to the agent, to like the buyer's agent, for example, which sometimes the reason, obviously, a buyer's agent would want that is if the seller is providing information or something of value to the buyer. So maybe it's they're buying a home warranty. And then additionally, it's a way to verify compensation, and anything being paid by that seller really shouldn't be in the buyer's hand, but it's typically in the listing agent's hand. And so I know that I notice a lot of title companies aren't allowing that because they're interpreting the division rules or the commission rules will say that they can't have it and they can't share it, which I don't interpret it that way. It's saying minimally, this is what you need to provide, but it doesn't mean you can't provide beyond the minimal requirement. So I don't know if that's something that can be looked at, if that's just too big of an issue to address with this. But I think it would be great to be able to say that, and that's on page. Hold on. Let me get that contract, that red line back up. Or maybe if you can scroll towards the end on the screen. Sorry, I'm trying to pull it.
Section 18.
It's towards the end. Hold on. Sorry. I closed out of it. Yeah, under the broker copies.
Well, the problem is you want to see it ahead of time, because if the commission is wrong, you're not going to know on the copy you're looking at. So you have to ask for the other one.
And if they didn't pay the roofer or they didn't pay the home warranty, you don't know. And some of these title companies are refusing to give it to the real estate agents prior to closing. And I find that problematic. I understand that the buyer shouldn't have that in their hands. They don't need it. But if you're a buyer, you need a buyer's agent, you need to verify that
ahead of time
that your
before
buyer
it's
is
signed.
supposed to receive is received, and you can't do that without seeing that closing statement. So I don't know if that's some language we can add in here to just clarify. I mean, it does say closing company must provide to each real estate broker in this transaction copies of all signed documents that such real estate brokers are required to maintain pursuant to the rules of the Colorado Real Estate Commission. And how they are interpreting that is that the rules say minimally what you need to provide, which doesn't include necessarily the settlement statement.
But it does say closing companies authorized by both buyer and seller to deliver their respective
respective, and that's where
maybe we take out respective.
Yeah.
Take out both. We could add in both or something instead of respective.
Is that something we're able to do on these forms? Anyone with authority?
That is directly into the confidential information we were talking about.
I
So
was going to tell you, I think you're going down that road of the big issue that tabled the listing contracts.
Okay. Gotcha.
that's one of those line items we can add on to for the discussion of that, how we would handle that, because it's very valid points.
Mm-hmm. Yeah.
Okay, any other discussion on this form?
Mm-mm.
All right, do you want to make a motion?
Motion to approve closing instructions with the recommended adjustments.
Okay, is there a second?
Second.
Okay, David, is there anybody wanting discussion?
Yes, we have one hand at this time. Mr. Cox, I have asked to unmute you, and so you should be able to unmute yourself.
Thank you, commissioners. The paragraph you were just talking about, paragraph 18, was actually what I was going to comment on, in that I agree with Commissioner Sanders. I see regularly where the seller is supposed to pay inspection items or commission or HOA dues or something within the status letter, and there literally is no way to verify that those things are being paid. I appreciate Director Waters talking about confidential information. I'm really not sure what's confidential on a settlement statement, but maybe there is a concern there. And maybe this one should be tabled as well with the listing contracts until we get that rule in place to know how that would affect each of them, because I do think there's value in allowing the settlement statement to be delivered to both parties for purposes of verifying that the transaction is being conducted in accordance with the contract. Thank you.
Okay, anyone else, David?
Yes, one additional hand at this time. Robert Howie, I've asked you to unmute, and you have 3 minutes to address the commission.
Thank you, Commissioner. I just want to go back on the discussion about the edit to what controls between closing instructions and the contract. Just an FYI, as a closing agent, we have been constantly reminded by the Division of Insurance that we are not a party to the contract to buy and sell, but we are a party to the closing instruction. So I'd like to give that clarification, please. Thank you.
Thank you.
Okay, anyone else, David?
That is all at the current time,
Okay.
Madam Chair.
All right, so do we want to approve this, or do we want to table it until we figure out how to get something in there about providing both sides of the contract to the agents?
I think it's a big enough issue to table with the rest, because I've seen it problematic. And, obviously the big problem with that is you don't want to ever have to go back to a seller because something was missed. You never want to do that. And so without being able to verify that, it is a problem.
Do you want to make a motion then to table it?
Motion to table the closing instructions, the October meeting with the listing contract.
All right, is there a second?
Second.
All right, any further discussion? Okay, all those in favor?
Aye.
Aye.
Okay, any opposed? Motion passes.
Okay. Let's see, next document up is the post-closing occupancy agreement. Second here, I've lost my screen. All right. All right, 1 second. There we go. Okay. So in paragraph 2, it's a non-substantive change. Move line from paragraph 3 to paragraph 2. Paragraph 3, made possession date and possession time defined terms. There are some non-substantive wording changes. And a proposal to clarify the language stating that the term of the agreement cannot exceed 60 days if the buyer intends to occupy the property as a principal residence, which is a requirement imposed by many lenders in order to fund a purchase as a principal residence. Paragraphs 4, 6, 7, and 8, proposed fixing of minor typographical errors. Paragraph 10, removal of language automatically awarding per diem damages to a holdover tenant, instead leaving it up to the determination of a court of competent jurisdiction on a case-specific basis. Paragraph 12, a non-substantive change for clarity. Paragraph 13, the proposal to delete a sentence and replace it later with a mutual indemnification provision that is created in paragraph 15. 16, clarifying language is added to comply with 3812-102.5 CRS, which limits the amount of security deposit that can be collected to a maximum of 2 monthly rent payments. Paragraph 17, fixing of a formatting error, and then paragraph 18, that bolding of the statement and the additional provisions. Yep, that's all I have. I'll turn it back over to the commission.
Any discussion?
Maybe a question. My understanding is that based on Colorado law, you cannot accept a security deposit without rent. And you know, we're not in that market right now, but in previous markets, you know, a lot of people would do post occupancies without rent. But then they would want the security deposit. Is that something that should be addressed in this form?
Commissioners?
And I don't know if
It has a spot for both things, right? It has a security deposit. Where's the?
Yeah, and you may be more of a expert on that, Renee, being in property management. Are you aware, is that an accurate law that you have to, in order to collect rent, you have to have in order to
It has been an
security
issue.
deposit, you have to have
It's
rent.
been an issue on the post-closing occupancies. So if someone, I don't know if we need to actually specify on here that, you know, you must have rent if you have security deposit, or just the fact that it has security deposit and has rent. I mean, if we're trying to make sure errors aren't made, we might need to put wording in there that says you must have rent in order to have, you know, security deposit.
Because I think, I mean, not everyone is aware of that. And especially if they're removed, you know, from property management, they may not know. So just a suggestion.
Melissa, do we need that clarification in there?
If that's something you guys would like to be added, then certainly.
And you know, the good thing is we're gonna have a discussion. So if there's anyone attending this meeting, you know, that have comments on it, you know, that they could comment. But I think it would be a good thing to have there.
Okay, where would it be added?
Under rent, I would say. Oh, yeah, under under security deposit, probably.
So I am, you know, I'm just gonna throw my ignorance out there on that one. I have not heard that before, that you cannot have a security deposit without any kind of rent. So I'm definitely deferring to you guys on that, but tell
Well, the
me
problem-
why.
Because if they don't move, that's one of the things about evicting them. You can evict them for not paying rent, I believe, is one of the reasons. You know.
And this is certainly not my area of expertise by any means, but I do remember, and my brain is telling me that this was a subject of a discussion during one of the forms committee meetings. So there may be someone here for public comment that can chime in on it.
Well, why don't we do public comment first?
Yeah. Commissioners, it was kind of the concept of like 0 times 2 is 0. So if you don't collect any rent, you don't get to collect a security deposit.
Right. But a lot of folks in the profession don't know that. So when we're getting them, when we're receiving them, for example, they'll, you know, they're like, if you're a listing agent, then the buyer's agent, they're trying to, you know, make the offer more appealing by putting 0 rent. but
Oh,
then
then
they
maybe-
include like 1,200 or something in the deposit. And then now we have to go back and say, well, you can't do that. And this is why you can't do that.
Well, but it's been added in there. It says not to exceed the amount of 2 rent payments. So,
But I don't think it's clear that you can't.
well, but if you have 0 rent, you can't exceed 2 times 0, which is 0. So it's already got the clarification in there, not to exceed the amount of 2 rent payments. So if someone is reading the form, they would know that you can't have 0 rent because 2 times 0 is 0. So maybe
I don't get that from reading it. I just
No,
get
yeah,
that
I don't get
it
that
can't
from
exceed the
reading this.
amount, but I don't get that you can't have.
it says right there, not
Okay.
to exceed the amount of 2 rent payments.
Yeah, but you
Right.
could still have 0.
You could still have 0, right?
Right, you could have 0 security deposit and 0 rent, but why would you do that?
I just don't know that everyone would make that connection.
We do have a hand up.
Yeah, we just asked for public comment.
All
And then-
right, David, do you want to see if anyone has comments?
Absolutely. We've got 2 hands up at the current time. Tammy Dietz, I've unmuted you and you have 3 minutes to address the commission.
Hello, Commission. I am not addressing number 16. I am actually addressing the fact that sometimes mid-transaction, we need to modify this form. And many agents are just making a secondary form. Then we have 2 completed forms filled out. Without a date on it, we cannot do an amend extend very easily that says one version is void. And there's just no mechanism to get rid of a first version if mid-transaction you're negotiating something different. That's all. Thank you for your time.
Is there not a date on this form?
It's just
There-
referencing the date of the contract.
Huh, okay. Well, that's a good,
That's very good.
yeah,
Oh, okay.
okay.
All right,
Was there-
Commissioners, an additional hand is up. Mr. Cox, I've asked you to unmute.
Yes, Commissioners, very briefly, first of all, there are additional provisions. Actually, I think adding a date on this form might not be a bad idea as suggested, but there also is additional provisions that you could say this version supersedes and replaces the previous edition without having to do an amend extend. And as for the security deposit, that comes from a statute that passed in 23 that says that the security deposit cannot exceed 200% of the rent. And I know that Mr. Donnelly has put it in at least one of the ACUs, if not 2. So I think he is trying to educate your licensees about this requirement that it does apply to post-closing occupancy agreements.
Can you clarify, Mr. Cox, if to your knowledge, if there's 0 rent, then that means 0 security deposit.
That's correct. Director Waters is correct. If you have 0 rent, you can't have a deposit. And that's what's caused a lot of consternation for a lot of brokers because as part of the deal, the buyer wants to sweeten it with, hey, we'll give you free rent, but they want a security deposit. So you have to figure out workarounds, which is not always easy, but that is true.
Thank you. So we have a recommendation to add a date to this document. And then I'm still also recommending to just provide a little clarity that you must have, in order to charge a security deposit, there must be rent of some sort, right? So I don't know the best way to, I don't know how we want to word that, but I think if we can incorporate that maybe into even the rent section.
I think that'd be very helpful.
Yeah, it's just a lot of confusion out there about it. And that just helps. Now it's another layer of protection for people, which I don't think will hurt.
Okay, but the new form, one of the changes is that has been added is not to exceed the amount of 2 rent payments.
But I don't think that's sufficient, personally.
Okay, if 0, well, I think it's sufficient, but I think we should have a date. And is there a signature on this page, actually?
There's a signature and there's dates by the signature.
Okay. Oh, there is a date.
Yeah.
I think they're talking instead of the contract, it's referencing the contract date, but it doesn't have a date like at the top.
Well, I don't know if it needs a contract date. I think we need this date, the date at the bottom, because if there's another one and that date is afterwards, that one.
Well, but if they sign on different dates, that's not an easy date to reference. I agree that it'd be easy to put a date up on top of the form.
Okay, Melissa, is that something that you can add?
I can. Do you guys know of any other forms off the top of your head that have a date at the top that I could model off?
Contract?
The only one I can think of is the property disclosure. Let me see. Well, I guess that's another issue if none of the other forms have it.
Right.
I guess I haven't paid attention to that. Let me see.
Contract has the date, stop.
Ms. Phipps, I brought up the current CBS residential, which does have a date at the beginning of page 1.
So is it okay if I just make it in that similar form?
Yep.
Okay, I will do that.
And then I still would like to propose clarification under rent. Or maybe, let's see, hold on. No, I think it's more appropriate, most appropriate under the security deposit to add a line that says, rent is something to the effect of rent is required to collect a security deposit. Something to that effect. But I think it's also important that this note is in here that says not to exceed the amount of 2 rent payments, because you could, in theory, have an individual that's trying to over collect on the security deposit beyond statute, right? So I think it's good to leave that, but I think it's also important to clarify that you're unable to charge, you can't collect a security deposit if you're not charging rent.
So would it help if it let in with, in order to collect rent, or in order to collect a security deposit, you must charge rent, the seller must charge rent, and then go into seller agrees that a security deposit in the amount of blank, not to exceed the amount of 2 rent payments payable to buyer, will be paid at closing and held by buyer?
I think that would be sufficient for sure. Yep.
Okay, any other discussion, or are we ready for a motion?
Yes, we do. Just got another hand. David Matthews, I've asked you to unmute.
Thanks. Just real quick on this one. This one comes up a lot in our brokerage with the deposits. I think the security deposit language should be clarified a little bit more to say monthly rent instead of 2 rent payments. Because if we look at 2 rent payments, I would look at that and say, okay, that's 2 of whatever's entered for rent. And if they're only rent, having a post-closing occupancy for 45 days or 25 days, I think that could get a little confusing. So just my 2 cents. Thanks so much.
Okay, Erica, can you add that into what you were gonna have, what Marcia said, as far as what you were gonna add?
So yeah, I was reading not to exceed the amount of 2 monthly rent payments. Mr. Matthews, is that your recommendation?
Yeah, that was.
Yeah.
Amount of 2 monthly payments. Okay. But do you have that down, Melissa?
I do.
So just to verify, because I was going to do kind of a more of a general motion like we've done today, but my understanding are the additions are going to be adding the date line, adding the language in regard to rent and security deposit, and then now changing this to say not to exceed the amount of 2 monthly rent payments. Those are the only changes, correct?
Yep.
Okay. Okay. So motion, sorry, where are we? I'm like, I gotta get on the right thing. Motion to accept the post-closing occupancy agreement with the proposed amendments.
Okay, is there a second?
Second.
Any discussion? Okay, all those in favor?
Aye.
Aye. Any opposed? Motion passes.
Right. The end is in sight, I think. This is number 12 of 15, the inspection objection notice. And proposed changes are pretty straightforward. At 1.1, removed an unnecessary or extra VAT. And then changed attached to provided, because again, it may not always be possible to attach a document to this contract. This accounts for the report to be provided in another manner other than attachment. And that's all I have.
Yay. Any discussion?
Nope.
Okay, let's make a motion.
Motion to approve the inspection objection notice.
Okay, do we have a second?
Second.
All right, David, any discussion?
Commissioners, I'm not seeing any hands at this time with respect to the inspection objection notice.
Okay, take a vote. All those in favor?
Aye.
Any opposed? Motion passes.
All right. Next one up is the extension or termination of contract. In this contract, the dates and deadlines provision in the extension section of the current version list provisions as if they're found in all versions of the CBS. The proposed changes are intended to clarify if a provision is only found in particular versions of the CBS, and if so, which ones. And then it also contains abbreviations for the particular versions of the CBS. You can see CBS 3 means a contract to buy and sell real estate commercial. And then in the dates and deadline section, if a particular section doesn't apply to all the contracts, that it's specified which ones it does apply to. Also added in an other dates and deadlines provision. And then going down to the notice of termination portion of the contract, makes the same changes as discussed above with the dates and deadlines table. And then clarify that any other terms and conditions not addressed remain the same. So that's it for that.
Okay, any discussion?
Have any questions?
I had a question about why line 52 is crossed off. I mean, if any items left blank, it means there's no change to the corresponding deadline in the contract. Why do we cross that off?
Line 52?
Yeah.
Oh, because I think I saw that somewhere. I think it's up top. So it's at 40 now. Line 40 now. They just moved it.
Yeah, my apologies. I didn't include that in my summary.
Okay. And get the new line. Okay. All right, any other discussion?
Nope.
Okay, someone want to make a motion?
Motion to accept the extension or termination of contract form as presented.
Is there a second?
Second.
All right, David, any discussion?
No hands at this time, Madam Chair.
All right, okay, we'll go ahead and vote. All those in favor?
Aye.
Aye. Any opposed? Motion passes.
All right. The agreement to revive contract. And this one, the proposed change is adding the dates and deadlines table from paragraph 3.1 of the CBS. And again, we made revisions to that table to specify the provisions that are only located in particular versions of the CBS. That's the same change that was made in the extension termination of contract. And then there's also a proposal to add a space where additional amendments can be written in. That's all I have.
Okay, any discussion?
None here.
All right, someone want to make a motion?
Motion to accept the agreement to revive contract as presented.
Second, anyone?
Second.
Okay, David, any discussion?
No raised hands at this time, Madam Chair.
All right, all those in favor?
Aye.
Aye.
Aye, any opposed? Motion passes.
All right. So I'll take a deep breath. We move on to the contract to buy and sell real estate, which is the 15th and final form up for review today. So this form was revised last year, and normally it wouldn't be up for revision again this year. However, it was opened up for revisions due to some recent legislative changes that affect it. And since it was opened up for those changes, the division is proposing to make conforming changes to those made in the manufactured CBS that you already considered. So jumping into it, again, a lot of these will be redundant to what you already saw in the manufactured CBS, so I won't try not to belabor those ones. 2.52, the title was inclusions not attached. However, the items listed in the provision are a mix of items that are both attached and not attached. To take this into account, the title was changed to inclusions additional, and the language, whether attached to the home or not, was added. 2.55, just changed the position of the word inclusion so that it's consistent with other provisions. And then there's a change that is not included in the red lines that you have, and that is the change pertaining to 4.4.1 good funds. And this is the same change that we already again discussed with the manufactured CBS. So that's just changing that language to comply with SB 25016. And then 8.4. All right, 8.4 this change was necessitated by HB 251219, which amends 38-35.7-110 CRS to require an owner of a residential property located within the boundaries of a metro district prior to or concurrent with the execution of a CBS to provide the purchaser with such a statement in writing. 10.1, this change was made at the suggestion of a forms committee member who felt that it was not always practicable to expect all sellers to have SPD completed by the date of contract, and this change has been reflected in previous contracts that you've already considered today. 14 is conforming change again to the manufactured CBS. And then moving on to 16.1.1. This is another change that was not reflected in your red lines that you had prior to today's meeting. The reason for this proposed change is that the applicability of HB 24B1001 was brought to our attention, and staff was waiting on some stakeholder feedback on how best to address this issue. So that act removes references to assessed value and ratio of valuation for assessment from taxpayers' notice of valuation and tax bills. So the proposed change in this language to assessed or actual valuation per the county assessor, it is felt by stakeholders that this would allow the closing companies to use the valuation from counties whether or not they provide the assessed value or the actual value. And then moving on to 22, the same changes are proposed to the mediation provision for clarity as were made in other contracts. However, due to an oversight, they weren't included on the red line versions that were presented to you today, but I will take note of that change that was discussed about what was the last sentence about, oh, this does say the obligation to mediate. That's interesting. Okay, so that change is already in there. Okay, and then 26, again, it's the same proposed changes that you've been seeing in the notice provisions throughout the contracts today. It was just an oversight that they weren't included on the red lines to this document that were given to you. And I do believe that's all I have.
Okay, any discussion?
I just have one comment / question. Years ago, we had the box that had countered and you had to initial that. Anyone know why we got rid of that?
That predates me, so I can't chime in on that.
Is Marcia still on the line? Director Waters?
Still here. I am
You know
trying to
why we
remember the discussion.
got rid of it? Because I'm going to tell you, there's still confusion, like particularly where I've seen it is instances like, let's say you have an out-of-state lender that's not familiar with our contracts. They don't understand that there's a counter because it doesn't really say it. It's just unsigned, and there's like a little note that if it's not signed, or don't sign if it's being countered. We have a case today that we're going to be discussing where this was a real issue because there was confusion on what contract, especially when you're sending variations of a contract, and so I think that we should maybe discuss bringing that back, which all it was just a little checkbox. And I always liked it. I didn't know why we got rid of it, but it's a little checkbox that says it's being countered, and then we had initials. And I think that could eliminate confusion. And then from this contract, you can see that there is an attachment, because otherwise you get comments that the contract's not signed and you're having to explain that, no, it's countered, but we don't sign it in Colorado, So I would like to see that back. I don't know if that's something, and I apologize if this is coming late for me. I did not even really revisit it until I saw that case, and I was like, we need to bring that back. So just a thought.
Okay, I anticipate that you have somebody that has raised their hand that's going to provide you with some information about that.
Okay.
With that in mind, commissioners, Mr. Cox, I do see that you have raised your hand. And it seems to maybe be in conjunction with this question.
Yeah, I'll answer this question. I have another thing too that I want to point out, but the reason that was deleted from the contract several years ago is because what we ran into was that sellers, when they would check the counter box, would end up signing it by accident because of the way software was set up. And then the buyer would say, well, you signed the contract, so we don't have to worry about the counter proposal. And it caused a lot of issues in the industry. And whether or not that's been resolved with the new software programs and everything else, I really do not know, Commissioner Sanders, but that it was taken away because it was a very, very big problem that we were having with sellers inadvertently signing contracts.
So what do you think if we were to add just a checkbox where there's no signature, just to indicate that there is an attachment?
Well, the problem is that we had that before, and what would happen is the brokers would say, hey, you got to check the box that says it's countered, and they would end up signing it anyways. So I'd rather say to have it vetted first to make sure that there's not going to cause inadvertent problems with sellers signing contracts for houses 50,000 less than what they intended to sell it for, because that's what was going on before. I'm sorry, did that answer it, Commissioner Sanders?
It did. Thank you.
The other one, and Mrs. Phipps might have fixed this in 2.5.8. It's a typo that's been driving me crazy since we did the forms. It's in the second part of 258. If you look at, and I can't see past David's box. Oh, there it is. It says written approval by such lender before closing. That should be lessor. And I think you changed this, if I'm not mistaken, Mrs. Phipps, you changed this in the manufactured home contract. But you see where it says buyer will or will not assume seller's debt and obligations under such leases for the lease item subject to buyer's review under 10.6 and buyer's receipt of written approval by such lessor before closing, because it's not a lender. And I think you changed this in the manufactured home one because we talked about it before. But since you're opening this contract, I just soon get it fixed here too. Thank you. That's all I have.
Thank you, Mr. Cox. If the commissioners are prepared there, we do have another hand at present. I believe that I'd seen another one, but it may have been lowered. But Liz Boyce.
Hi, Elizabeth Bosey with Transactioner, which is the new contract software that we are trying to take over Colorado. And I just wanted to state that with the our version of Colorado contract software, that we can handle that checkbox if needed. I mean, that's what smart software should be able to do, and to prevent mistakes. That's kind of something we pride ourselves on. Although I cannot speak for the other platforms out there, but I just wanted to put that out there. Thank you.
Thank you. Well, commissioners, with that, I do not see any other hands at the current time.
Okay, do we have any further discussion? We need to add lessor instead of lender in 2.5.8. Is there any other discussion? Anything else?
Was there any further discussion on the checkbox from any of the other commissioners?
That was my recollection too on what Damien said. Going back to that, there were errors, even though the software could handle that. It was operator error. And so they took that out, and it has resolved the problems, I think, probably for the most part. I know what you're talking about, Eric, on this one, but we just, I think I would be hesitant to add that back, just because I know that even if the software can handle it, there would be operator errors in that one, and we could have some huge mistakes being made. But I do see where you're coming from on, you know, you send it off to the lender, they just don't see that there's the additional counter proposal. We just have to have additional higher level of communication, I think, when we do that at the moment. But yeah.
Okay. Well, we will just leave it the way it is for now, unless anyone else thinks we need to have it, like me. But we'll, you know, this is something that can be maybe addressed down the line when we can see all the new softwares, all the updates, and maybe down the line it's something that can be readdressed.
Okay, does someone want to make a motion?
Motion to approve the contract to buy and sell with the recommended amendment or adjustment.
Okay, is there a second?
Second.
All right. Any further discussion?
I guess I should clarify that the recommended adjustment is to, or I should say, instead of adjustment, let me redo the motion. Motion to approve the contract to buy and sell with the recommended correction.
Of lessor instead of lender.
Yeah,
Okay.
lessor.
All right. Okay, Erica, you want a second again?
Second, yes.
Okay.
Can I interject about that? I'm sorry, Commissioner Lang. Just for clarification for my purposes, since I'll be charged with making the corrections, Mr. Cox referenced a change to the manufactured CBS, and that change wasn't made in the manufactured CBS.
Okay, can we go ahead and have you make that change as well? We need to go back and amend the motion for that, but we should.
Well, the problem I'm having is looking back at the manufactured CBS. That, and I don't know how to explain this without being able to pull them both up. Let me, bear with me 1 second, please. I've got 100 documents opened on my screen here. And the manufactured CBS, if we're making sure we're talking about the same thing. David, could you scroll to 2.58, please? Sorry. Well,
go up.
What was the one that?
It was 258, but those don't correspond.
256 in this one.
Okay.
Yeah. It says if buyer does not receive such wires approved from the lessor. So this one is correct. So the manufactured one is correct. It does say lessor.
Yeah.
Okay, so he's looking at the leased items.
Yeah, on line 82.
Okay, so then on the contract, the regular contract to CVS, I think I wrote down the wrong provision number. So that was my confusion. Which exact provision?
So it's 2.58 and
Okay, thank you for that clarification.
okay, so it's line 83 here.
Okay.
Lender should be lessor. Okay.
Okay, thank you. Sorry.
Any further discussion? Okay, all those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes. Okay, we need to take a break and grab something to eat because we haven't even started on the investigations. How long of a break do you guys need?
15 minutes, maybe?
It,
Is that too long? 10, 15 minutes? I don't know.
okay.
I appreciate the break. I forgot to eat breakfast, so
Yeah, okay.
dying right now.
All right, let's meet back at 2:15.
Okay, thank you.
Okay.
Commissioners, before we break, do you mind if I just make a slight note to the agenda for the upcoming complaint investigations?
Okay.
We are removing complaint matter P from the agenda.
Okay.
Okay.
And just in case anybody was waiting on that one, I wanted to alert you and the participants of that fact before we head into our break.
Okay. All right. Thank you.
Thank you.
Okay, it looks like everybody is back. That was the shortest 15 minutes ever, but
Have never eaten that fast.
no kidding. Okay. Now we're going to move on to complaint matters.
Okay. All right. Hello, commissioners. Welcome back. All right. Your first complaint matter is complaint matter A, which is complaint number 2024-2213. On December 12, 2024, the division received a complaint from the complainant stating the respondent was to represent him as a buyer's agent in a wholesale transaction. The complainant stated he gave the respondent $200,000 in cash as the respondent was to deposit the money in the respondent's bank accounts with the intention of having the funds then wired to close on the wholesale property. The investigation noted that the respondent failed to obtain a signed exclusive right to buy contract in a timely manner and failed to provide brokerage relationship disclosures to the complainant. It also appears that the respondent failed to deposit the complainant's money with his employing broker. The transaction ultimately failed to close in part because the respondent and the wholesaler did not return or wire all the complainant's money for closing. The wholesaler admitted to using some of the funds for another project of his. The respondent did not transfer the funds to his employing broker, and the respondent acknowledged that his brokerage prohibits brokers from accepting cash during transactions. Additionally, the respondent submitted 2 offers to the seller for different purchase prices and failed to realize which contract was countered and the actual purchase price of the contract until the closing took place. The respondent directly returned approximately $145,000 to the complainant, and the wholesaler directly returned approximately $104,500 to the complainant for a total of $249,500 returned to the complainant. Possible violations include 12-10-2171G, failure to timely place deposit funds, 12-10-2171H, 12-10-2171I, 12-10-2171M, 12-10-2171Q, 12-10-4051B, and possible rule violations include Rule 5.2, Rule 5.9, Rule 5.10, Rule 6.2, and Rule 6.5. Recommended disciplinary action includes a final agency order, public censure, a fine of $5,000, a 2-year probation following a 3-month suspension, and courseworks in brokerage relationship, contracts, and ethics. And myself and investigator Marcy Rivera are here to answer any questions you may have.
Okay, do we have any discussion on the first one?
The only thing that I really noted, there's a lot of violations, and I think most of this is appropriate. I actually felt in this case the fine was a little low.
What would you like to see for the fine?
I would say 7,500. There was so much wrong here. And the fact that this individual deposited this person's money in their account, and it was just really, really inappropriate. And then I don't even know, it was unclear if the person has even gotten all their money back.
So
different accounts of like what is owed, but the complainant
correct
making it seem like they still owed them money, whereas the respondent is making it seem like he's finally paid everything back. So
that is correct. All 3 of the parties involved kind of had varying degrees of a story as to how much was owed, how much was paid, who handled the cash and what time. So really the investigation at least tried to focus on what could be proven as actually trading place or exchanging hands.
Yeah, and to be honest, if there was never an exchange, it wouldn't be a conflict, So I would say to me all this looked good. I just think the fine should be a little bit higher.
Okay, Erica, Autumn, what do you think about the fine?
I would actually support that, and I think it's a good idea.
I agree. Absolutely.
Okay, does someone want to make a motion?
Motion to accept the disciplinary recommendation with the following changes. Increase the fine to $7,500.
Okay, do we have a second?
I'll second.
All right, any further discussion? Okay, all those in favor?
Aye.
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 Any opposed? Okay, motion passes.
Okay, your next matter is investigative matter B. This is complaint number 2024-1992. On November 6, 2024, the division received a complaint from the complainant stating she agreed to hire the respondent to rent her property with an option to purchase after unsuccessful attempts to sell the home. The complainant alleges that the respondent failed to remit rental proceeds for the past 4 months and has failed to respond to the complainant's communication attempts. The investigation noted the complainant has since terminated management services with the respondent. The respondent didn't respond to the complaint. Subpoenaed bank records show that tenants' rental payments were made to the respondent, yet the complainant was not paid her rent. Bank records show that the respondent used 2 bank accounts to hold rental income and commingled funds amongst 4 other accounts. The respondent failed to hold trust funds in trust accounts or label the accounts holding funds of others. It also appears that the respondent allowed her unlicensed husband to perform real estate activities. It appears that the respondent owes the complainant approximately $4,700 in rental proceeds and $8,100 in the fee charged to the tenants for the lease option contract. The bank records also show that the respondent used approximately $34,439.16 on trust funds for personal expenditures. The bank accounts have been closed where the respondent is unclear where the money was transferred to. It also doesn't appear that the respondent has a designated account for holding security deposits, as those funds appear to have been commingled with rents. The respondent currently has 3 other open investigations with similar allegations. The respondent's website shows 2 active sale listings in Grand Junction. Possible violations include 12-10-217-1H, 12-10-217-1I, 12-10-2171M, 12-10-2171Q, 12-10-2171W, and possible rule violations include 5.2, 5.5, 5.9, 5.10, 5.15, 6.3, 6.25, and 7.1. Recommended discipline action includes final agency order, public censure, revocation, $30,000 or max fines, revocation of the brokerage firm license and refer respondent to criminal law enforcement, and a direct referral to the Attorney General's office. And myself and investigator Marcy Rivera are here to answer any questions you may have.
Is there any discussion? All right, someone would like to make a motion?
Motion to accept the disciplinary recommendation as presented.
Do we have a second?
Second.
All right. Okay, any further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Okay, next is investigative matter C. This is complaint number 2025-608. The respondent did not disclose to the Division of Real Estate his October 4, 2024 Class 4 felony. The respondent accepted a plea agreement for aggravated motor vehicle theft in the first degree in exchange for the dismissal of a second charge of felony motor vehicle theft in the second degree, no jail at sentencing, a 2-year supervised deferred judgment, restitution, and possible early termination. The respondent's arrest and conviction were the result of investigations by Denver Police and Arapahoe County Sheriff's Office into fraudulent VIN for a vehicle purchased from the respondent and the subsequent arrest of 2 suspects known to the respondent. Text messages from one of the arrested suspects' cell phones revealed months-long communications between the suspect and the respondent discussing specifics about motor vehicle theft, such as vehicle registration without a legitimate VIN, disabling GPS to prevent law enforcement tracking, filing a fraudulent insurance claim for stolen vehicle involved in an accident, and the respondent's coordinated response to Denver Police inquiring about a vehicle he sold that was later found to have a fake VIN. The respondent explained he had no way of knowing the vehicle he bought from a previously unknown wholesaler was stolen because there were no issues registering the title and insuring the vehicle. The respondent suggested he was targeted by law enforcement only because he bought multiple cars from the wholesaler. Possible violations include 12-10-2171M, 12-10-2171N, 12-10-2171P, 12-10-2171W, and Rule 6.23. Recommended discipline action is a final agency order, public censure, revocation, and a $10,000 fine. And myself and investigator Jay McLean are here to answer any questions you may have.
Okay, any discussion? Okay, would someone like to make a motion?
Motion to accept the disciplinary recommendation as presented.
We have a second.
I'll second.
All right, any further discussion? All right, all those in favor?
Aye.
Aye, any opposed? Okay, motion passes.
The next investigative matter is complaint, or is matter D, complaint number 2025-604. On January 22nd of 2025, the respondent pled guilty to felony menacing, a class 5 felony, and menacing, a class 1 misdemeanor. The respondent was ordered to serve 9 days in jail, credit for 2 days served, complete an 18-month deferred sentence, 18 months probation, and pay $1,382.70 in court costs and fees. The fees have been paid and the deferred sentence and probation are ongoing. On December 2nd of 2024, the respondent pled guilty to assault 3, a class 1 misdemeanor, child abuse, a class 2 misdemeanor, felony menacing, a class 5 felony, and assault 2, strangulation, a class 4 felony. The respondent was ordered to complete a 4-year deferred sentence, 4 years probation, and pay $4,675.37 in court costs and fees, as well as $1,520 in restitution. The fines and restitution have been paid and the deferred sentence and probation are ongoing. These convictions were not disclosed to the division. Possible violations are 12-10-217-1N, 12-10-217-1M, 12-10-217-1P, and Rule 6.23. Disciplinary recommendations are diversion, a fine of $500, and probation to run concurrent with a criminal sentence. And Investigator Martinez can answer any questions.
I do have a question. I was wondering why the recommended fine was so low, considering there were 3, looks like he has, or she or whoever, they have 3 cases. They didn't disclose any of these to the division. And it just doesn't seem in line, and it's a felony, and it doesn't seem in line with like what's been recommended across the board with these types of cases. So just kind of curious to understand what the thought process was for the low fine.
Sure. Typically, we recommend a $250 fine for not notifying us, and then $250 for the actual conviction. But you're welcome to change it.
I mean, just even looking at what we're going to get next, it just doesn't seem in line. You know, it seems kind of low. Did any of the other commissioners have anything to say about that?
Well, by that logic, if it's 250 per conviction, there's one. I mean, are we just counting the felonies here at the 250?
It's not per conviction. It's just for the crime itself that they were supposed to report to us. So we just looked at it as the whole incident together.
Yeah, this is what we normally do.
Historically, yes, but you're welcome to discuss it and change it.
Okay. I mean, I think it's just going to come up later. That's all. When we see similar cases that have higher recommendations, but that was really my only comment, as I just thought it was low in comparison to some of the other recommendations that are on the table today.
And I just wanted to confirm on the probation, it looks like to run concurrent with the criminal sentencing, so their license will be put on hold. Is that accurate?
probation.
So they're still able to practice?
Correct.
Okay.
Did you want to change something with that, Autumn?
It's just, I'm just thinking, you know, in all the situations where this has come up in past meetings, we've waited until they've gotten through. Gosh, I'm sorry, guys. My brain is not braining right now. Until they've gotten through all their probation and all the necessary things in order for them to actually get retention of their license back. But
normally we do that when it's a licensing case. This person already has their license, so it's a little bit different. So this is what normally is done because they are currently licensed. If you're wanting to do something different than probation, we can talk about that.
Just scary, considering the scope.
Yeah, I mean,
a different recommendation.
I'm going to yield to you guys. If you have any suggestions or thoughts.
Erica, either one?
Well, I've stated I thought the fine was a little low, based on, again, some of the other recommendations. Also, I mean, I just think if this is the tone, we got to keep that consistent throughout the case.
Well, this is because they didn't report. It's not a real estate violation. It's because they did not report the conviction. So normally, as Nicole said,
there is a real estate violation. The violation is not reporting. So there's 3 violations plus a rule. I mean, so it is a violation.
Right.
Which is fine. I'm just saying we gotta be consistent as we move through this agenda. So I'm okay with this if that's the kind of how we if it's typically done that way and it's just based on the non-reporting of it. So $500. That's fine.
Okay. Any other discussion? Does someone want to make a motion?
Motion to accept the disciplinary recommendation as presented.
Do we have a second?
I'll second.
All right. Any further discussion? Okay, all those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, motion passes.
Okay, the next is matter E, complaint number 2025-606. On February 14th, 2025, the respondent pled guilty to offering a false instrument for recording, a class 2 misdemeanor. The respondent was ordered to complete a 4-year deferred sentence, pay $2,684 in court costs and fines, and complete 100 hours of public service. The deferred sentence is ongoing, and the respondent is current on his monthly payments. The conviction was not disclosed to the division. Possible violations include 1210-217-1N, 1210-217-1P, 1210-217-1M, 1210-217-1W, Rule 6.23, a final agency order, and a fine in the amount of $2,000. And I believe that this one was different because he already has a stipulation.
Yeah, he had
there's a
multiple
current stipulation. I know that there was a past, but is there a current stipulation right now?
I believe so. Let me look this up.
There's
there was
one
a
in
reason.
2001, one in 2020, and one in 2024.
Yeah, so the terms of the 2024 stipulation were completed. It looks like there's a stipulation in the ESP folder for the appraiser license. However, I don't see a signed version, so I'm not sure if he's actually agreed or consented to the stipulation yet.
That's correct, Paul. That is still a pending matter.
So is that why, because this is one of the examples I was talking about, and there's a few through today where it's like the bar is kind of low on the last one, but then this one is so high. And this one, is a misdemeanor versus felony. So I'm just trying to understand.
Exactly.
Yeah, I understand that too. And the reason is because he is under stipulation on 2 different boards. And we discussed this with the legal counsel too. That's why the fine was higher on this one. It's not just not disclosing and a conviction, but there were additional, it's in the report, but there were
Yeah.
additional issues with him.
Which I did note there were 3 previous disciplines. I didn't see that they were active though. It just like looked like it was in the past. It didn't look like it was present day.
Penny, you might be able to speak to that more.
Well, I think that part of this too is with each one of these, you may see slightly different recommendations based on sort of the underlying conduct and whether that conduct is such that could translate into harming consumers that they're working with. And for filing a false instrument, certainly somebody in the real estate industry knows you know the implications of that, and that is unacceptable. Taking money from a vulnerable person, those are things that I think that at least in the discussions that we had, we considered the underlying conduct and could that potentially transfer into their role as a real estate broker. And so that can add to the discipline, as well as the fact that they've had previous issues or multiple issues. So all of those kind of things are taken into consideration.
Yeah, and reading through this, the other thing that complicated it is that it was family, and to be honest, if I'm just transparent, it just seemed kind of like a messy situation. So that being added, it wasn't like a member. We don't really know the full story. It wasn't like a regular member of the public. So it's kind of hard, like reading this individual's response versus, you don't really know what really happened there. So anyway, those are just my questions.
Exhibit 9 was pretty compelling, though. And I would hope that, because it was a family member and a vulnerable family member, it wouldn't be deemed as any less significant than if it was just the general public. And so,
yeah,
but it's your all's decision.
No, I'm just, reading both. It was 2 sides, it's like, obviously he did plead guilty. So for that, I give that precedence. If someone pleads guilty, then that is how we proceed,
So he's on probation for 4 years. So we also need to add to the referral that he needs to be on concurrent probation. That
You're
one.
right.
Yeah, so if we can, so we just need to add that when whoever is making a motion. So is there any other further discussion? Okay, does someone want to make a motion?
Oh, go ahead. Go ahead.
Okay, I'm going to take the load off. I feel like you've been doing it all day. I move to accept staff recommendation with the modification that probation should run concurrent.
Okay, is there a second?
Second.
All right, any further discussion? Okay, all those in favor?
Aye.
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 Aye, any opposed? Okay, motion passes.
Okay, matter F is complaint number 2025-596. On February 28th of 2025, the respondent entered a plea of guilty to menacing real stimulated weapon, a classified felony. The respondent was ordered to complete an 18-month deferred sentence, 18 months probation, and pay $1,321.50 in court costs. All fines have been paid and the deferred sentence is ongoing. The matter was disclosed to the division by the respondent's attorney. Possible violations include 1210 C17 1N. Disciplinary recommendations are diversion and a fine of $250 and probation to run concurrent with the criminal sentence. And Investigator Martinez can answer any questions.
Okay, any discussion?
Nope. I'm sorry, I keep going out of frame writing.
All right, does someone want to make a motion?
A motion to accept the recommended or the disciplinary recommendation as presented.
Okay, anybody second?
Second.
All right, any further discussion? All right, all those in favor?
Aye.
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 All right, any opposed? Motion passes.
Matter D is two complaints. Complaint number 2024-1332 and 2024-1520. Complaint concerning the respondent was opened by the Commission on October 2nd, 2024. The complaint alleges that the respondent wrote an employing broker letter on behalf of a Colorado real estate broker licensed applicant, stating that she was aware of his criminal history and would be supervising him as his employing broker. The letter was included with the real estate broker license application, which was submitted to the division around May 24th of 2024. On April 18th, 2024, the respondent signed a stipulation agreeing to downgrade her license to an associate level and should have been aware that the license downgrade would become effective on June 2nd, 2024. The second complaint concerning the respondent was opened by the Commission after the respondent submitted a letter to the division stating that a licensed individual was going to act as her employing broker. On August 20th, 2024, the division received notice from the licensed individual stating that he had not authorized taking on the respondent as her employing broker. The respondent's counsel has not provided a statement as to who wrote the employing broker letter and if the licensed individual approved the letter. Possible violations include 1210-217-1A, 1210-217-1C, 1210-217-1Q, 1210-217-1W, 1210-217-1M, and disciplinary recommendations are public censure, a final agency order, revocation, and a fine up to $12,500. And Investigator Martinez can help answer any questions.
All right, any discussion?
I was just curious, did you ever get the paper trail about that supposed letter from the broker?
So,
No.
the broker had confirmed that he had not written any statement for that. We did try to verify with ESP if they still had the original email that the letter was provided with, but it was not. However, the written response for that complaint does indicate that that was emailed over to the division. And that's the response. I'll give you the exact exhibit. Hold on one second.
No, I did look, I was just wondering because it was kind of left that as an investigator, you were seeking the paper trail of that letter because the managing broker is saying, I didn't send that. And then the respondent is saying, yes, you did. And so I know that you were looking for the paper trail. I was just wondering if you ever found that, if that ever came.
Yes. So ESP did not have the original email. However, in Exhibit 9, the response from the respondent's attorney, down there at the bottom of the page, it's confirmed that the respondent provided the letter to one of the staff members in ESP, and the email that was sent to the staff member included the subject letter. So that's at the very bottom of page 1 on Exhibit 9.
Right. But it was not the email was not from the person she alleged sent it to her. It was from her.
It appears, yeah, the statement appears to indicate that it was coming from the
her,
respondent.
not
Yes,
him.
correct.
Okay.
Yeah.
Now, are we talking about two different letters though, right? Because there's two different issues here. I'm sorry to interrupt.
No, that's okay. I'm speaking specifically to because to me, the one that held the most weight, especially for revocation, was there was a managing broker who the respondent said she could move her license to that individual, and there was a letter that was sent. And so to me, if a letter was sent, I would think that there would be some sort of paper trail where that individual that she's claiming sent it to her, you could paper trail that, right? And so that's what I was asking, if they had received any information, because it was kind of left open that was never provided. So I just wonder from then to now, if anything was provided specifically showing that he did send it, and obviously they weren't able to provide that, so we can only assume that it was not sent.
Right. And so I did follow up with the attorney after our interview, and I still haven't received a response to my questions in the emails that are specifically asking what the origin of that letter was, who wrote it, etc.
Thank you. And I'm just asking because, we're seeking revocation. So I just, wanted to make sure that piece was still left the way it was when we reviewed it, which it is. So.
Yes.
So my questions, this was really messy and it was very difficult. It was a difficult interview to listen to on some of these. And I found it that, you had the two complaints that were there. And so I had to separate those out on the various levels, particularly as we're talking about revocation. And on the first one, it seemed that she was already moving through some of this process and had written that letter before she knew what her stipulation was going to be. Is that correct?
That's what was explained. Yes, she actually went out of her way to clarify that it was several months before the stipulation was entered into, that letter was drafted.
So she had drafted that letter for that person. If we're talking about issue one, had drafted that letter ahead of time, and then that person had that, and she didn't know that that had been submitted following the issues that she had going on this. And that person that submitted it even admitted she didn't know that he'd submitted it after the fact.
So
oh, go ahead.
I'm sorry, go ahead. I didn't mean to interrupt. Please finish your thought.
No, you're fine. So that, as messy as that was, and trying to gain clarity for that, I felt like I had the clarity there. It was not good. She should have had some additional conversation with him afterwards, but she just didn't know months later that he had not followed through on that. And if he had, it sounded like he had submitted it and they had kicked it back and said, you need more information. So he was going back and forth with the division, correct, on whether he could use, whether he needed more information or not. She was not privy to his dealings on that one. So it was a little less, I could see where there would be problems there, but it was a little less of an issue. This, to me, the second one was certainly that a letter was being provided potentially, that she was moving to this other company, and a managing broker didn't know. So I listened to that. And it's very interesting because she was texting back and forth with this managing broker, and he would respond, she's saying, I want to, I'm going to join you. And he responds perfect, basically. And his audio interview shows that he admits he discusses with her, but then states that they would have a lot more discussions to do. He did not have a policy manual in place yet. They hadn't discussed commission splits or office fees. He says he never heard back from her, so he never went back through those next steps. But there was a letter referenced in a text from the respondent, as well as the investigator in the audio transcriptions, that the employing broker was going to take responsibility for the respondent. That letter was key, and Erica brought that up as well. So when there was an interview with the attorney, and it sounds like they were going to go ahead and draft that letter that was a requirement for the real estate commission. They would need a letter of responsibility for who's taking on this next agent. She says that she thinks, she didn't say it was, but she thinks that that is the letter that they are referencing. And so because of, and I'm sorry, I'm just going through all of my notes on here, because of the conversations between that managing broker and that agent, he is telling her basically, yeah, you can do this, but he didn't accept responsibility. She moved forward thinking that she was going with that company. I don't believe that she did anything saying that she wasn't, that she was doing it without his permission, that she was doing it without him knowing it. There was a lot of communication. It seemed like that she's like, hey, I'm moving this stuff over. This is what I'm doing. And he just ghosted her.
Well, I'm sorry. Go ahead.
Yeah, I just wanted to, there should have been clarification. She should have had written documents with independent contractor agreements. I mean, there's agreements that we know that need to be signed, but she was moving forward and he never said anything for it. So I do want to just bring that up in all of this conversation, that He could have, at the very beginning, stated, we are not a match. You are not coming to my brokerage. And that did not happen. And she kept moving forward on that. And I do think that it's highly unfortunate that him not being clear with her from the beginning could cost her dearly in this. And it's really important to know.
So can I just chime in real quick? To your point, that's how I looked at it initially, which is why I asked a question that I asked, because if you look at and I don't have the exhibits in front, I mean, I can get them, but I'm not looking at them right now. But in one of the exhibits, it was her transfer basically to Dora. It was something that she sent over to Dora, and it had a letter specifically from that managing broker. And that's problematic. So the question is, did she forge this letter to the managing broker? And no one, the managing broker is saying, I didn't send her that letter. We talked about it, but I honestly never confirmed it. And at the end of the day, like now I don't even want her. So he's saying he never prepared that letter and he never provided that letter. She's saying he did, but they weren't able to paper trail where he sent it to her. So like if he emailed it, and I think I'm
She
sorry,
said it
I
might
think
have been a
he sent it as
text message.
which is
Yes.
highly unlikely that a managing broker is going to send a letter like that via text.
Agreed.
So that being said, that's why I asked that question, because I was like, well, if he really did provide it, then we shouldn't be going for revocation. But in the situation where she forged a letter, potentially, allegedly, to a managing, from a managing broker without his permission, that is problematic. And so I felt like that would justify more of what is being asked here versus, and that's why I wanted that clarification. But I have one more question, Paul. Based on the violations, since there are 2 cases, are we looking at fines based on the 2 cases? Because I do think there's a little bit of, that first case is a little iffy just because she may not have really known that. And all the evidence kind of suggests that she didn't know that he was going to send it when he sent it. So I don't know that that's her fault. And
yes,
the fine is kind of based on the second issue.
So I don't get to determine what the amounts of the fines are going to be. Ultimately, that's going to be up to the team lead and the attorneys. But in the conversations, it seemed as though the general bulk of the fine was connected to complaint 2024-1520, which is the second one involving the letter from the employing broker.
And if I may add just one thing here, part of this and one of the violations is a violation of the previous order that was signed. And in that previous order, in paragraph 12, there's several subparts, but in paragraph C of 12, it does say that the respondent agrees that if they violate that order, that the outcome is a revocation and max fines. So that's partly how we got to this recommendation as well, because they already agreed to that. And we believe that the issues with this inappropriate falsified ER letter is a violation of that order that she agreed to. And so if that helps, that's part of the determination in this.
Thank you for actually bringing that back up, because I feel like I was so, I remember that now, but I got so focused on the other stuff, because obviously forging a managing broker's signature and sending it over is very questionable. So I think I focused on that, but that makes total sense.
And on the first issue, she was in negotiations with me very early on from her first action that was going to involve, she knew at the time she wrote that letter for her, and I don't know if it's still boyfriend or if they're married now, but it is somebody that she's in relationship with, that the commission was seeking a downgrade and of her license. So it wasn't, there's a little more knowledge there to the whole big picture about what was going on. And honestly, the first issue that we have a signed stipulation from, involved some misrepresentation, some dishonesty, some not getting things right. So it's a bit of a pattern of conduct that we're seeing.
Okay, thank you.
Okay, is there any further discussion?
But we do not have a copy of the letter.
The letter is Exhibit 6.
So it's typed
Sorry.
and it's not
No,
signed.
no, I'm sorry, hold on. That's the other letter.
We have the letter, Erica.
The letter, but yeah, not
We
the.
don't have the proof that he sent her the letter.
Correct. Yeah, the paper trail. And in the interview, she had represented that most likely it was sent to her via text message. She wasn't able to provide a text message, so we followed up with the attorney to try to see if there was any additional information that we could get as far as the origin of the letter, but we got no response from the attorney.
Well, in my notes from the attorney interview, it said that she thinks that the letter, and these are just my notes, so this is paraphrasing, is referencing that the new employing broker would now be supervising the respondent at a high level. So it wasn't necessarily a letter that she would be signing, just in compliance.
Yeah, and hold on one second. Let me just okay. I feel like we have the letter in question from the employing broker. I just want to make sure that everybody has that.
Yeah, it's there. It's not signed. It's just typed. So
Right, yeah.
anybody
Yeah.
could type it.
Yeah, and if she wasn't able to produce proof, because that's really all that was needed there, like some sort of proof that he sent it to her, then I think we could reconsider, right? But without that proof, then we can only assume that she did not get it and that this is something that was typed up by her, since that is what the managing broker is saying. He's saying he did not provide that letter.
Yes, the employing broker is adamant about the fact that he never gave confirmation to the respondent that he would be taking her on as her employing broker. And though there is communication there, he kind of went out of his way to clarify that there was never any full confirmation that he was going to take her on. Those discussions in the emails, there doesn't appear to be some communication about it, but I don't see anything in there that says for certain I'm happy to take you on or I'm willing to take you on as your employing broker.
Yeah.
And so the letter in question from our employing broker on the second complaint, that is just be under Exhibit 7. Yeah. So yeah, Exhibit 7, page 2 is the letter that was received, and then under so pages 3 through 9, they show the email communications between the division and the employing broker as to whether or not he had actually authorized this letter or drafted this letter.
Okay, does someone want to make a motion?
I motion to accept the disciplinary recommendation as presented.
Do we have a second?
I'll second.
Okay, any further discussion? All right, all those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Oh,
I'm opposed.
You're opposed?
Yes.
Okay, one opposed, motion still passes. Okay.
Okay, matter H is complaint number 2024-1407. The complainant alleged in her complaint that the respondent was conducting real estate activities with another broker whose license was inactive. The investigation could not substantiate those allegations. However, the investigation found that the respondent failed to maintain compliance related to brokerage relationship disclosure in writing and transaction file requirements. Possible violations include 1210-217-1J, 1210-217-1K, 1210-217-1M, Rule 6.20, Rule 6.5, and Rule 6.6. Disciplinary recommendations are coursework in brokerage relationships, coursework in contracts, diversion, and a fine of $1,000. And Investigator Gabarty can help answer any questions that you may have.
Anyone? Any discussion?
Nope. No.
I thought the fine might be low on this one for the number of things that were missing as far as all the disclosures and listing contracts, seller property disclosures. You know, there's so many things. I thought the fine was low.
They did add though, like coursework and stuff too. So I don't know. I was okay with it. What did you recommend the fine be?
I would say 2,500. There are just so many issues with names and licenses and not having the paperwork. It just was kind of a mess. It was hard to tell if this was all up and up or not. And
Well, I think what they discovered though was they couldn't substantiate all the allegations. The only thing that they could is that her or this person, I don't know if it's his or her file, you know, wasn't up to par, which I think based on what we've done, it seems about what we've done in the past. If we're just looking at one file being out of whack, we'll say, because all those other areas in the complaint doesn't look like they were able to, you know, determine that those were true. So I think the fine's okay.
I think the coursework and the contracts was pretty important. I found some of his statements and everything a little flippant and dismissive on that. So I think that just a rework on the contracts will be very beneficial to know that you need all of this in your file and it's there for a reason.
Yeah, I was trying to find.
well, also based on that response, and his response would be another reason why I think the fine should go up, because there wasn't remorse and admission. So
I'm sorry, I'm still trying to, I don't want to lose my screen here. I'm trying to find it online.
that's okay. Autumn, you have any thoughts?
Kind of in between. But to your point, yes, his letter just was very kind of to the point. I don't know. It's currently at what, 1,000?
Yep.
Is that where we were? We meet in the middle and do like 1,500 or 2,000.
Okay.
Yeah, I think 1,500 would be okay. I think 2,500 might, I don't know, maybe excessive.
I know we're trying to set an example, right? And sometimes lessons need to be painful so they're remembered, but.
Okay. Any other discussion, or Autumn, do you want to make a motion?
I will motion to accept staff recommendations with the revision of fine to 1,500. unless you guys have other thoughts to that.
Do we have a second or discussion?
Second.
All right. Any further discussion? All right. All those in favor?
Aye.
Any opposed? Okay. Motion passes.
The next is matter I, complaint number 2024-1736. A complaint was filed against the respondent, who was the complainant's landlord, alleging that he did not return the complainant's last month's rent for almost 2 years. The investigation found that the respondent did not comply with license law concerning trust accounting and record-keeping requirements. Possible violations include 1210-217-1M, 1210-217-1I, 1210-217-1Q, Rule 5.2, Rule 5.5, Rule 5.9, Rule 5.10, and Rule 5.14. Disciplinary recommendations are a final agency order, public censure, coursework and trust accounts, coursework and property management, and a fine of $5,000. Investigator Peters can answer any questions that you might have.
Okay. Any discussion? All right. Anyone want to make a motion?
Motion to accept the disciplinary recommendation as presented.
Do we have a second?
I'll second.
All right. Any further discussion? All right. All those in favor?
Aye.
Aye.
Any opposed? Okay. Motion passes.
All right, matter J is complaint number 2025-833. The respondent previously held a real estate broker license in the state of Ohio. His Ohio license was permanently revoked on May 1st, 2025. The settlement agreement, to which he consented and agreed, found 5 violations, including dishonest dealing, failure to oversee operations, failure to respond to a subpoena, failure to maintain a place of business, and failure to maintain required trust accounts. The respondent stated that he had agreed to be the managing broker for a property management company, the owner of which was unlicensed. He stated that the unlicensed owner had agreed not to engage in brokerage activities and to not manage the firm. The respondent stated that client funds in the amount of $45,000 were not deposited into escrow accounts. He stated that the owner is making restitution. The respondent stated that he himself was not required to pay restitution and had never received any funds. Possible violations are 2 counts of 1210-217-1X and 2 counts of 1210-217-1AA. A disciplinary recommendation is a final agency order, public censure, revocation, and a fine of $10,000 or whatever max fines may be over once the settlement is complete. And investigator Hardy's here to answer any questions you may have.
I will say I do like that he self-reported. Because typically I feel in these situations they don't. And I don't know if that would give consideration to the fine. I mean, revocation, if it was revoked there based on, you know, these violations, revocation is still on the table for sure. But also because we're revoking, I don't know. I would be open to give consideration to the fact that he did self-report by reducing the fine slightly.
What do you have?
It's already revoked anyway, so. It's like,
did you have a fine in mind?
Probably like between $500 and $7,500. Only because it's already revoked.
What I can tell you
to do, right? But that was a recommendation. So realistically, does it that make, I don't know. This is just my thought.
Penny, did you have something?
I just wanted to share with you that through the negotiation and settlement process through ESP, we often do stay a portion of the fine when it comes to a revocation. And so there is some adjustment that you allow us to do under a delegation of authority.
Okay.
This recommendation just comes with keeping it consistent. And basically, because it is self-reported, we didn't add a violation of failing to report, and the fine therefore is reflected that way. But, you know, it's still your decision, but there is, you know, we understand in the settlement process, people giving up their livelihood, sometimes then we make adjustments to that fine.
Okay. Right. Then that makes sense. Especially if it's likely that may be revisited down the line.
Okay, anyone else? Erica, Autumn?
No, I was okay with actually going with staff recommendations, but happy to have a discussion regarding the fine.
And I will say, after I'm hearing from Penny, I'm going to walk back that comment because I think it's going to it may potentially be revisited at some point. So there's no point in addressing that now.
Okay, does someone want to make a motion?
Okay, I'll move to accept staff recommendation.
Do we have a second?
Second.
Any further discussion? All right, all those in favor?
Aye.
Any opposed? Okay, motion passes.
All right. Matter K is complaint number 2024-1142. The division received a complaint alleging that the respondent misrepresented the nature of the exclusive right to buy contract. The buyer stated that the respondent told him his signature was required on the ERTB as an insurance precaution. The buyer subsequently bought a home in a private transaction during which he received no brokerage duties from the respondent. After closing, he received a letter demanding payment to the respondent for $16,600. Through the course of the investigation, it was determined that the respondent engaged in brokerage activities with the public through exclusive tenant listing contracts and exclusive right to lease contracts. The respondent collected payments directly from the clients and was not paid brokerage compensation through her employing brokerage. Possible violations are 1210-221, 1210-217-1C, 1210-217-1T, 1210-217-1W, and 1210-217-1Q. Disciplinary recommendation is public censure, revocation. There should also be final agency order. Clicked with that. And then a fine of $12,500. And I apologize, there is an additional violation also of 1210-217-1M. And Investigator Hardy is here to answer any questions you may have.
And just to clarify, you said that final agency order should be checked?
Yes, I apologize. With revocation, that includes a final agency order as well. That was just a mistake to not have that checked on the
Thank
form.
you.
Mm-hmm.
Any discussion?
I'll start on this one. This was really kind of tough on a few things as I went through it. I do think that we have, a couple of different issues. And I'm just referring back to some of my notes on here. When they were talking about the exclusive right to buy, they said that several times, like much of the information was in text over a long period of time, and that was in WhatsApp, but it was in Hebrew. Was there any request to follow up and obtain these texts? Because that would have answered a lot of the questions, I think, on that one. Was there any pull for those to get translated or obtained?
We did not ask for a translation for that.
Okay. So taking these two issues separately, going on the exclusive right to buy outside of the texts and going on the interviews, and then into the data, unless I missed something. So I would definitely love to get some additional input from the commissioners, but
She disclosed the agreed upon compensation and the exclusive right to buy, which is what she's required to do. Both the complainant and respondent agreed in their interviews that they never brought up excluding the current rental on the exclusive right to buy. That would have been their out on that particular one. The complainants reached out months before the respondent to start the conversations, but they even reached out 5 years prior. So she was answering questions for them for years while they were deciding whether they wanted to rent or buy. When they reached out, in this last scenario, I found that she did her job showing the properties that they wanted to see. They had numerous follow-up conversations in person, on the phone, and in the texts about market conditions, education, renting versus buying, general processes, lending, and a variety of options. Nowhere in the information did they mention any misunderstanding of the documentation she sent over. Or no misunderstanding that they would owe her money for her efforts. So thank you for giving me some time on here, because I just have a lot of notes on these. They did want to see what else was out there. They wanted to learn all about how to buy a home. They wanted due diligence. They wanted to see a lot of options. They wanted to know the process from start to finish. They wanted a lot of education. And the agent, it seemed to me, did so in good faith on her end. Then they sought additional counsel from another agent, their landlord's brother-in-law, who, although didn't charge them any compensation because he was doing it a favor as his family, he said in his interview they should have read the contract. They did. He knew they owed her money and said that he personally wouldn't have handled this. So this is not a popular topic necessarily, and a lot of us would have handled this very differently. But I think my question is going to be important. Because he didn't know how much work she'd done over the last 4+ years. And then they offered then to pay her $500 and increasing it incrementally over negotiations to $2,500 for their perceived 1 day of work. But again, as much as the public doesn't realize, a lot of licensees work a lot more than just what you see them. It's a lot behind the scenes, and this was over years. So I believe because they knew they owed her money and they were hoping they'd take less, they wanted to get rid of the realtor fees there. So I do think that buyers must take responsibility for signing documents. They both acknowledged signing it. They agreed to the terms, and the terms covered a purchase, whether it was on the MLS or a for sale by owner. They ended up purchasing a for sale by owner. I found her very credible on this particular issue. So I'm putting the other issue aside because we do have 2 issues. My question is, if we are okay with buyers signing contracts and asking licensees to work, spend their hard-earned money, time, effort on your behalf, and then saying you don't want to pay the compensation, this is going to be highly problematic because we deal with a lot of contracts that buyers and sellers are signing. This then goes into a review on all of those purchase contracts, counter proposals, amendments, and resolutions. Where do we draw the line where we have to believe a person read and understood that document? Or do we only do it if a licensee is trying to collect their compensation? And one thing that was very interesting to me, and I wrote this in quotes because it was quoted at the end of the interview for the complainant, he said, "She wants to get paid and I don't want to pay." And I just thought, well, yeah, she's worked for years on that one. I think that revocation and public censure is steep on this. She had no previous stipulations. I didn't find her at fault with several of the potential violations, so I'd remove those. We can talk about her getting paid outside of her employing brokerage. I think there were some miscommunications on that one as well, but thoughts on some of that. Those interviews were highly informational.
I think one of the major issues is that she had a lot of communication with the wife in the scenario. And she even admitted that she discussed with the wife over the phone about the exclusive right to buy listing contract. She never talked to the husband. She assumed the multiple places in here, it says she assumed that the wife would talk to the husband. Well, you don't get someone to sign a contract by just talking to one person. You are supposed to sit down and explain it to everyone who is signing the contract. And she admitted that she hadn't done that. And the wife obviously was not necessarily telling the husband everything. Whether she understood or not, we don't know, but she did not tell him, and he didn't understand. I mean, when they went to the showing and she said, "Oh, it's for insurance purposes," and he signed. He didn't. So there was a lot of confusion, and she didn't do her part on explaining what was being signed and going over everything. So she didn't, okay, she showed him 2 houses. And she did not do anything on the other sale. She didn't have any fiduciary duties, any responsibility of a broker responsibility on the sale that they purchased. So I guess I'm kind of on, over a little bit. I don't agree that, she necessarily deserve this. And just because you talk to someone for years, we don't know what they were talking about. Were they talking about, oh yeah, I'd like to buy a house? Or was she really sitting down with them for hours on end, educating them? It didn't seem like that. It seemed like it was more of a casual thing. And then it got more serious right before they actually looked at a house. And she should have sat down with them and had them sign documents beforehand. She sent it over the night before they were supposed to go look at houses. And it was like they were putting the kids to bed. They didn't have time to look at it. And clearly she didn't explain to the husband. So I think there were quite a few issues with that she didn't do what she was supposed to do.
I'm gonna, I'll chime in and, Erica definitely brings about some good points. And I just went back to just revisit that, exclusive right to buy. So she did have an active contract. I don't recall, and correct me if I'm wrong, especially Pat, if you know, I don't recall there being a notice to terminate from the buyer, anything in writing for the buyer to terminate their agreement.
Terminate their exclusive right to buy.
Mm-hmm.
That's correct. There was nothing.
Right. So by the term just of the exclusive right to buy, first of all, I totally agree that like we cannot, I mean, I think it's going to be a real problem if we tell people, if people can say, well, I didn't read the contract, and that's used as an excuse for, litigation. Like there is an obligation to read it. And her contract had a note of termination. There was an out in the contract. So if they read it, they still could have come back and said, we don't really like the terms of this agreement. We want to terminate this contract. So she did have that in place in her contract. It's in the additional provisions. It specifies, that buyer or broker may terminate the agreement in writing, right? So, I do think that sometimes it boils down to a consumer maybe not wanting to pay. Like she said, she probably doesn't want to pay. It's hard to validate whether or not she said that it was insurance for insurance purposes or what she even meant by that. But I do think that there wasn't some sort of obligation for that buyer to review this contract. And I don't know that when we're talking about revocation, right, we're not just talking about fines and discipline. We're talking about revoking someone's license over someone who may or may, we don't know what context she meant insurance. She could have just meant like insurance on her maintaining her relationship with them. We don't really know what she meant by that. So that being said, she also had a contract in place with a holdover period. So technically, because she had a holdover in her contract that says compensation would be due, she would have the right to at least approach them for compensation based on her contracts with them that they signed. So I'm I guess, more siding with what Erica is saying based on the exclusive right to buy that was signed, and also based on interpretation of what she meant by insurance. Because we're taking that literal, but I can also see where maybe that wasn't so literal. She might have just meant an insurance for like securing her position as their agent. I don't know. I really don't know the answer to that. But when we're looking at revocation, these are things that we have to look at.
If I could just add one thing, I don't know if it'll matter for you, but she also had in her exclusive right to buy and the additional provisions, I believe, that they acknowledge and they had instructed her not to show them any property where the seller wasn't offering a buy-side co-op, if that helps any.
I did see that. And while it would not be a practice that I would participate in, with all of and this was written, what, March? Hold on. Last year. Around that time, there was a lot going on, and we were very uneducated about what was going on with the NAR lawsuits, settlements, and all of that. And I do think that a lot of agents jumped the gun on clauses and things that probably really shouldn't be there. And I do know that there were conversations with buyers, because buyers, when they understood, oh, wait, I may have to pay my agent, there were those conversations happening, especially early on because there was no direction. There was no direction from any entity, from from our level to National Association of Realtors to the industry in general, right? And so I take that with a grain of salt, because if her fear was that if she had a conversation with her client that, hey, just so you know, you are responsible to pay anything above this amount, they may have had a conversation that they don't want to pay anything above. I don't know, right? We don't know. And I think today we probably wouldn't see that in a contract is often, but let's kind of look back to when this was written and what was going on in the world of our industry then. So I take that with a grain of salt. I just don't think that would be grounds to revoke. And like I said, based on the fact that she had a holdover, I probably wouldn't have done it, but I would have probably just let it go. But she had really a right to, because of her contract, request that commission. I don't think it was in good taste. If I was her managing broker, I would say, don't do it. But
Well,
is
her
it illegal?
managing
I don't know.
broker did say that. Her managing broker said that he would not pursue collecting that money.
Right.
And then that's when we got into the fact that he didn't really know what she was doing. The fact that she was receiving payments directly for placing tenants, he did not know about that. And then also the brokerage is missing the transaction files that are required for the real estate commission. So it's not just the sale issue, it's the other issues too, where how can you work for a brokerage and you're collecting money directly and it's not going through the brokerage and your managing broker doesn't have a clue what you're doing? This is not, it's just not a good situation.
Yeah, I thought that was definitely more of an issue. Obviously, this one is one we have to discuss. But that is definitely still an issue, the collecting money without the broker knowing. In regard to the files, I also I was going to ask about this later, but like, are we holding some of these brokerages accountable? Because this particular brokerage has a couple of issues, even that we're seeing today. And I'm like, at the same time, where is the supervision? Which I know it's hard to, if you don't know, you don't know. And it's hard to supervise that, but that was just kind of a sidebar. So Erica, did you have any comments on I totally agree with you on on that part of it. Did you have any comments on the other items, which was her not like her collecting fees without going through the brokerage?
Yeah, so the only thing that was there, it sounded like initially she'd received a small gift and she asked the broker and it was for a lease, and he went into some dialogue on, if it's a small amount, it's just more work and cost and effort than it is for us to document that, so you can just keep that. I think she thought that was the way she would continue on that. They did not have, it sounds like, a follow-up discussion on how those should work. So that is something that the broker has said that they now have ironed out, and they are going to be working on her files. I mean, they've got this all ironed out moving forward. I do think some of that came out of a miscommunication. I do think that we can leave that on there for the violation of the statute, commission paid through brokerage. That clearly happened. Whether it was a miscommunication between the broker and the associate broker, that shouldn't have happened. That's on both of them. But I don't think that she deliberately misrepresented. I don't think that she was trying to do dishonest dealings on that. And I would remove some of those. I would remove those from her violations.
And I noticed
unworthy incompetent practice. I don't think that should be on there based on the review that I did.
Erica, are you saying you'd step back on the revocation as well?
Oh, absolutely.
And Garrett has his hand up. I just noticed. Sorry.
I'm sorry, commissioners. That was a holdover. I was going to ask that you discuss what your conversation eventually led to, which was the undisclosed compensation, whether or not you felt like this respondent was forthcoming there, whether or not that contributed to either a pattern of deception or a pattern of miscommunications. And it sounds like that's where the discussion was going. So I was just going to ask you for that.
Yeah, I felt like it was miscommunications between because she was the one that went to her broker asking, how should I handle this? But it was on the first one. And then I think she didn't have follow-up conversations with him as they went. Now, I don't know that for a fact. That's me just gleaning from his response and her responses to those. And they went furthermore to say, and we have a plan in place moving forward to make sure. In fact, one of them is, for the next year, every single one of her contracts will be, all of her files will be gone through at the brokerage level. They've got another person involved to make sure. So I feel like, he'd probably been like, you're potentially fired. This is so bad. And he would have said she was misrepresenting us. She was doing this, against our advice. He never said that either. So that is my thought process on those, and and sometimes you just have to pull out what your thoughts were on what they were doing on that. I don't know.
I do agree with you that some of the violations probably could be removed. I actually think that probably only 2 of them, which would be the deliberate misrepresentation and the dishonest dealing, but I do think that there was still unworthy and incompetent practice because of the second issue, which is, competent, hey, I probably should bring this through the brokerage, but I do understand that I can see how that miscommunication happened, but she should have known better, I guess. So I do think that the unworthy incompetent practice could stay. I don't know. I'm kind of agreeing that revocation might be a little excessive when we have other things like suspension and other options. I think jumping into revocation based on, that first issue with the exclusive right to buy, I do think that might be a little excessive.
Do you have a recommendation, something you want to do?
With suspension, I really don't know what that looks like. I've only
Suspension, they
part of a
don't get to
couple of
practice.
cases, and I don't know, do we come up with a timeline? Is there a typical timeline? Those are things that I probably need a little bit of guidance since we haven't had a lot of suspension cases.
I would jump in to say that if we are going to peel back on the revocation and go to either a probation or suspension, that we identify some coursework to ensure that this doesn't happen again in the future.
Absolutely.
Good
Yeah.
idea.
Yeah.
Well, and knowing that the brokerage is now doing, you know, a high level of supervision, or we can put on there a high level of supervision for X amount of time, then we wouldn't need a suspension, right? Because they're already implementing some of these things that we would want on there.
It would be a probation.
Probation.
I almost said prohibition. I don't know why, but probation.
Looking at some more.
With probation, you'd still have the final agency and the public censure, right? Is that typical?
Yes, Commissioner.
Okay.
Do you want to make a motion?
Commissioners, could I ask one more question before you get to that point? This was a question for Investigator Hardy. Was there any concerns about how forthcoming this respondent was in providing transaction files?
Well, I felt like I had been very clear in what I was asking for. And when the transaction files came to us, they identified as the 3 most recent. And it was only when we looked through the contract software that we realized that those were not, in fact, the 3 most recent, and then got copies. So she described that as being a misunderstanding, that she thought we were just wanting 3 that were an example of what she was doing. But I believe I had been pretty clear on what the request was, and the response came back and identified it as meeting the request.
Thank you.
Mm-hmm.
I mean, yeah, I don't like that she asked for compensation, but I also think that the exclusive right to buy allowed for that. I definitely don't like that she was taking tenants out and collecting, I know those fees are minimal. There might be $100 or whatever, but it still should go through the brokerage. Even if the brokerage gives her all of it, it still should go through the brokerage.
Well, and some of them were thousands of dollars. So she was getting the later one. Well, they were all several $1,000s that she was getting.
On the lease fee?
Yeah.
Oh, I must have, okay.
Yeah, I think there were,
I mean,
sorry. I was just going to confirm what you were saying, Commissioner Doyle. There were, I think they totaled around $14,000.
Total, altogether.
Total, yeah. But I mean, that can vary all across the state. It's just going to vary, but still she was paid. If you look at those, it was a significant amount. So I don't want to lessen that by any means.
I think suspension. Because I think we have to slap her hand, right? Like that's not good. But I don't know if it rises to the occasion of revocation, just given her exclusive right to buy. And like I said, I am concerned about the public being able to sign documents and then say, well, I didn't read it. So, that I just don't know that is acceptable. We don't want to promote that either, right? But then also we don't want to promote misrepresentation. So that issue.
It's the licensee's job to explain the contract to the people signing it. Period, end. You don't just give somebody a contract and go read it and sign it and get it back to me. It is your job to sit down and explain this to the client, and she didn't do that. So I don't think that you guys are kind of going, oh, it's not that big a deal. It is a big deal. She didn't do that. She didn't explain. She, like, oh, here's this thing. You got to sign it because we're looking at houses tomorrow. And said they were busy, they didn't have time to look at it. They had kids they're putting to bed, and then it was like, here, you got to sign this. So she did not do what she needed to do. I'm not saying it has to be revocation, but I'm saying that doesn't deserve a slap on the wrist. That deserves something more serious.
Suspension is very serious. That's not, I'm
Okay,
saying
so
it's not
how long is suspension?
That's some significant discipline. So I'm not, recommending just a diversion. I'm recommending a suspension.
How long is suspension?
Minimum a year, 1 to 2 years. I mean, that's a discussion amongst us, but.
Okay, if you're suspended, you can't work. So that is huge. If you are saying a 1 or 2 year, that's just like a revocation. I mean.
But there's a path back.
Well, you can also apply after you get your license revoked, and you can get it faster than 2 years. You can reapply in a year. So.
I think, Erica, if you did a probation for that duration with like a lot of supervision from their employing broker, along with courses, additional course classes for education, and we can discuss the fine, that's probably something that's a little bit more palatable versus suspension. So I don't know. It's really
I don't know what's typical for suspensions. I have very little experience with that on this board. So
I don't know that there is the typical for that.
I would love for input on what would be appropriate on a suspension, and maybe